Okay, good morning, everyone. We're just waiting for some more people to show up and for the instructions from the competition to get started. Okay, so everyone stand by. Are both of the experts in the courtroom?
Yes.
Yes.
Okay, thank you. Can I please have just one representative from each team confirm that all of the jurors are in the courtroom? I'm sorry, all of the witnesses.
All prosecution witnesses are present.
Thank you. And defense?
I believe, yes, all defense witnesses are present as well.
Thank you. And all advocates are here and ready to proceed, correct?
Yes, Your Honor.
Yes, Your Honor.
Yes, Your Honor.
Thank you.
Yes, Your Honor.
Okay, and I see that all the jurors are present too. So I'm going to let the organizers know that we're ready to get going, and I'll be back in a minute or two, okay? Okay, good morning, everyone. I'm going to ask that everyone now make themselves visible. That includes the jurors as well, and all of the participants, witnesses, everybody, okay? Thank you. Okay, so before we get started, let me just give you a few instructions I have to give you. We're about to call the case of West Carolina versus Timothy Ray. My name is Judge Constantine Yellis. Scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video in a second when I tell you to. And once you do that, these should remain off until trial ends. You should also have your video set to hide all non-video participants. This means the only people on the screen will be the advocates and me once we get started. However, before we do any of that, and if you need help with how to hide non-video participants, I can show you how to do that. Before we do that, however, everyone look around the room and make sure you do not recognize or know the jurors, and that the jurors don't recognize or know any of the participants, such that there aren't any potential scoring conflicts. Okay, so I'm going to give you a couple of minutes to do that, or a minute to do that. And if I don't hear anything in a minute from anyone, I will assume that there are no conflicts, and then we'll get started. Okay. All right, so it appears we don't have any conflicts. That's good. Okay, so let me just repeat what I said earlier. Scoring judges, please look to the two buttons on the lower left of your screen and turn off your audio and video. These should remain off until trial ends. You should also have your video set to hide all non-video participants. This means the only people on the screen right now should be the advocates and me. Okay, thank you. You can all close your video now. I'm waiting for the all clear from the competition organizers, and then we'll get started. Okay, we are now calling the case of West Carolina versus Timothy Ray. Good morning, everyone, once again. I'll now take appearances.
Good morning, Your Honor. My name is Taryn Boyer. That's Boyer. And I'm here with my co-counsel.
Good morning, Your Honor. My name is Alexandra Bustamante. That is Bustamante.
And together we represent the defendant, Mr. Ray, and we are team 101.
Good morning, defense. Prosecution, appearances, please.
Good morning, Your Honor. My name is Erica Reber, Reber, and I'm here with my co-counsel.
Good morning, Your Honor. My name is David Levine, Levine.
Good morning.
And together we represent team 104.
Thank you. Just one moment. Okay. So at this time, if there are any housekeeping or substantive motions in limine, we can take them up, starting with the prosecution.
Thank you, Your Honor. Prior to proceeding, we do have a few preliminary matters as well as one motion in limine. It is our understanding that the federal rules of evidence and federal rules of criminal procedure apply to this proceeding. Accordingly, we would move to invoke Rule 615, the sequestration of all witnesses, barring the defendant, Mr. Ray.
Okay. Defense, do you have a response to that?
No objection, Your Honor, as long as our expert is allowed to remain in the courtroom.
And that's okay with the prosecution?
Yes, Your Honor. Experts, we would move the experts be allowed as well.
Yeah, excellent. In that case, we have an agreement. Anything else?
Additionally, we anticipate the parties will make objections, which ordinarily would require us to approach the bench. However, for purposes of this proceeding, may we assume a constructive sidebar? Or would you like us to ask every time?
No. So you can assume that the original objection and the grounds for the objection are within within the presence of the jury. However, you can also assume that all the subsequent colloquy and arguments are constructively outside the presence of the jury. And no, you don't have to specifically request that we take a constructive sidebar.
Thank you, Your Honor. The state also has one motion in limine. Would you like to hear that now?
Let me first hear housekeeping issues from the defense.
Thank you, Your Honor.
Your Honor, given the unique nature of today's trial, when introducing any exhibits, is it all right if we reference the page number of the court and the counsel and witness to the electronic case record that we have?
Yes, in fact, I'm going to specifically ask that before you reference any of the information in the case packet or any of the exhibits, you direct court and counsel to the page that you're referencing, okay?
Thank you. Your Honor, may we assume that all witnesses are pre-sworn?
Sure.
And additionally, Your Honor, pursuant to the pretrial order, all the exhibits have been pre-numbered. May we retain those exhibit numbers throughout the trial?
Yes, I think that'll be the most convenient way to do it.
And that concludes our housekeeping matters, Your Honor.
Okay, excellent. In that case, I'll start with motions in limine if there are any from the prosecution first.
Yes, Your Honor. We have one motion in limine today. Our motion in limine is a motion for inclusion. We seek to have exhibits 18 through 21, and those are on pages 95 through 98 of the case file. We seek to have these exhibits deemed admissible under rules 401, 403, 404B, and 405.
Okay. Going to give the defense a chance to respond. You can take a moment to flip to those exhibits if you choose to first. Just one moment.
Thank you, Your Honor. And counsel, you said that was 18 through 25?
18 through 21.
21, okay. Yes, Your Honor, we will object, or we object to the admissibility of these photos on the grounds of relevance and also 403.
You're talking about, you're objecting to the admissibility of all three of these photos. Looks like three different photos of the same object, correct?
Yes, Your Honor.
Okay. And your objection is on 403 grounds?
And relevance.
Okay, I'll hear your objection now.
Your Honor, there is no probative value to these photographs in that we admit that Mr. Ray buried his son. The purpose of these photographs would only be to invoke the sympathies of the jury for the death of a young child and to inflame their passions in direct violation of Rule 403. The probative value is substantially outweighed by this unfair prejudice.
Okay. State?
Your Honor, no elements of first-degree murder have been stipulated to or admitted as far as the prosecution is aware. The prosecution has the burden of proving that Timothy Ray did kill Nathan Ray. Evidence that Timothy Ray buried Nathan Ray's body in these bags, as seen in these pictures, is relevant to helping a trier of fact believe that he did, in fact, commit the murder. As to Rule 403, the prosecution has the ability to present evidence in the manner it so chooses. And because the temporary insanity affirmative defense is relevant, is important here, the jury needs to have the full picture of how Timothy Ray acted, not just in the moment that he killed his son, but also in the time following. We have no direct way of prying precisely into Timothy Ray's mind at the moment of that murder. Therefore, any evidence we have around the time of the murder, such as a couple days later as seen in this evidence, is extremely important for the jury to understand his state of mind, his intent, and his mental capacity to form plans and form intent as seen in these pictures. Under Rule 405, because his character and mental state is an element of the affirmative defense, specific instances of character are allowed to come in, such as this. And under Rule 404B, this evidence is not being used to show that he acted in accordance with the character described here or shown here, but instead to show his motive, intent, or plan.
Okay. I'll give defense last word on this.
Your Honor, as the defense has already stated, we are not intending to contest the fact that Mr. Ray did actually kill his son, nor the fact that he buried his son's body, which can be brought out through testimony. The fact is that these photographs do not add to make anything more or less probable in this case because of that agreement. What we do contest is that Mr. Ray had the mental state to have committed first-degree murder. And as the government has just argued, they are trying to show that because he buried his son after the fact, that he had the mental state at the time of the actual crime. And that, Your Honor, means that it is prejudicial and the probative value is substantially outweighed by the danger of that prejudice.
Okay, thank you. So my ruling is I will permit these photos to be introduced. I'm swayed by the prosecution's argument that they're relevant to the issue of insanity of the defendant's mental state. As just to make sure that the record is clear, I am not considering, nor am I making any decision on the state's Federal Rule of Evidence 405 argument. The basis of my ruling is merely that it's probative of the defendant's mental state, and the potential prejudicial value does not substantially outweigh that probativeness. Okay, any other motions in limine from the prosecution?
Your Honor, if I may, in hearing that ruling, we request that only one of these photographs is admitted. These are all photographs of the same image with different angles, and additional images are just not necessary to prove their point, and it is highly prejudicial.
I think because they're, like you said, essentially all the same image, that there is no prejudice to admitting three as opposed to one. It's just different angles of the same object, to the extent that the different angles provide different information to the jury by which they can deduce something about the defendant's mental state when he committed the act of, that's depicted in the photo. I'm going to allow all three photos to come in.
Yes, Your Honor.
Your Honor.
I'm sorry, yes.
I'm sorry. Just to be clear, there are actually 4 photos included here. It's 18 through 21.
Okay, all 4 of them.
Thank you, Your Honor.
Prosecution, anything else?
We have no further motions in limine at this time.
Thank you. I'll hear from the defense.
Your Honor, we have no motions. We're ready to proceed to trial.
Excellent. Okay, before we begin with the opening statements, we will now hear opening statements from each party. Everyone should make sure that they are in speaker view. That button is in the upper right of your screen. Attorneys, please remember to mute your audio when the other attorney is speaking. Okay. And with that, we are ready to hear opening statements. You may proceed when you're ready.
Thank you, Your Honor. May it please the court, opposing counsel, members of the jury. Controlled, calculated, precision. These are the words that describe the actions of the defendant, Timothy Ray, on October 17th, 2018. This controlled, calculated precision and need for perfection and punishing anything less are ideals ingrained deeply in Timothy Ray's mind and ingrained long before the day he murdered his son. On October 17th, 2018, the air here in Skelton is crisp. Leaves are falling, crunching under the feet of last-minute shoppers trying to score their last-minute Halloween costumes and ensuring they have plenty of candy for all the trick-or-treaters they anticipate this year. But little did the people of this idyllic small town know, horror won't just be on their TV screens this year. It will unfold right before their eyes, and there will be one less trick-or-treater this year. On this morning, 6-year-old Nathan Ray is enjoying breakfast with his daddy before a long-anticipated day of first grade. He's eating his favorite breakfast, Frosted Flakes and apple juice. He's enjoying this time with daddy and trying to be on his best behavior now that he and daddy don't have breakfast together every morning. Then it drops. Uh-oh, it's headed right for daddy's computer. Nathan watches in horror as the apple juice spills all over the counter and heads towards daddy's laptop. Daddy doesn't like accidents, and he will be very angry today. Tears welling up in his eyes, Nathan braces himself for the screams that are about to come. Nathan runs to the safest place he can think of, his room. Each second feels like forever as he waits for daddy to come punish him. Sure enough, not long after, daddy does come to his room, screaming at Nathan for what he's done. How could he do this? Here come the exercises. Nathan tearfully starts his jumping jacks in his high knees, trying to swallow back those tears that are starting to spill down his cheek. Nathan pushes himself harder and harder to make daddy happy. But no matter how hard he pushes himself today, daddy just won't let him stop. Daddy won't tell him he can stop the exercises. Nathan is so tired, and it's tough exercising through the tears. So maybe, just maybe, if Nathan stops exercising, daddy will let them go back to breakfast and they can finish out their day. To Nathan's relief, when he stops, daddy goes to his room. Daddy leaves Nathan alone. But to Nathan's horror, daddy quickly comes back, this time with a belt. Whap, whap, whap. Each time daddy hits Nathan with the belt, Nathan cries harder. I want my mommy! I want my mommy! I hate you! Nathan yells back, no longer able to stand how much this hurts and how much he just wants his mommy to make this stop. Mommy, mommy. These are the last thoughts Nathan Ray has before daddy wraps that belt around his neck and begins squeezing harder and harder as Nathan struggles, squeezing and squeezing until the life is drained out of Nathan Ray. Now, Nathan Ray is dead. He won't be finishing those Frosted Flakes. He won't be trick-or-treating in his Halloween costume this year, and he won't be hugging mommy again. Now with Nathan dead, controlled, calculated, precise, Timothy Ray must try to figure out what he can do. How can he hide what he's done? How can he explain what he's done? Well, members of the jury, luckily Timothy Ray's efforts to hide what happened to Nathan that day failed, which is why we're here today. Members of the jury, my name is Erica Reber, and as my co-counsel David Levine and I discussed with you during jury selection, we represent the state of West Carolina in this case. We also discussed with you briefly that we bear the burden of proof in this case, beyond a reasonable doubt. Reasonable doubt does not mean any doubt. Rather, reasonable doubt is a specific doubt you can point to. It's beyond, I just don't think he did it. It's a reason for the doubt, a piece of evidence that doesn't add up, a witness you didn't find credible, something you can point to and say, this is why I don't think Timothy Ray should be held accountable for the brutal murder of his own son. Today, we will hear from officers who interacted with Timothy Ray following the days of his son's murder. We will also hear from experts who evaluated the interactions of Timothy Ray and these officers, as well as interactions throughout Timothy's lifetime, both before and after the murder. As we hear this testimony, members of the jury, you have the most important job in this room. As we listen to each witness, your job is to evaluate their credibility using your common sense, the strongest tool you came into this courtroom with. You must use your common sense to determine what you think really happened that October morning. Now, after hearing from each witness and seeing each piece of evidence, my co-counsel David will stand before you once more and review this evidence As he discusses each piece of evidence, your common sense will leave you with only one reasonable conclusion: that on October 17th, 2018, Timothy Ray murdered his son in cold blood with controlled, calculated precision. Members of the jury, we are all responsible for our actions, and we ask that at the close of this case, you would hold Timothy Ray accountable for his actions and return a guilty verdict.
Thank you. Defense, whenever you're ready.
Thank you, Your Honor. When someone has schizophrenia, it is like there are multiple voices living inside their head. The volume is turned all the way up, preventing the person from hearing their own thoughts. At one moment, the voices are yelling. The next, they whisper. They command. They say horrible things. You're worthless. Everyone hates you. Stay aware. Careful. They're following you. The police are hunting you. Run. Hide. Don't fall asleep. Your wife wants to kill you. Don't go out. Don't talk. Don't move. You're worthless. It is like a horror movie playing on repeat. The voices are going and going and going and going and going and going. And it is like the person is being tortured by their own mind. Welcome to the life of 2.4 million Americans. Welcome to the life of Timothy Ray. It is October 17th, 2018. Father and son are getting ready for work and school. Suddenly, son knocks over his juice at breakfast, spilling it all over dad's laptop. Father kills son over spilled juice. But October 17th was much more than that. You see, no one cries over spilled juice. And no one kills their son over spilled juice. We're all here today because the prosecution has charged Timothy Ray with first-degree murder. They have the burden of proving beyond a reasonable doubt. That is the highest burden of proof possible. Today, we have a burden too, but it's not the same as the prosecution's. We only have a burden of clear and convincing evidence, which basically means highly probable that Tim suffers from a mental illness and that he was unable to appreciate the wrongfulness of his actions. You will see today that it is impossible that Tim committed first-degree murder. It is impossible because of three things. One, schizophrenia is a reality-bending mental illness. Two, Timothy suffers from this mental illness. And three, Timothy was not in his right mind on the morning he strangled his son. When someone has schizophrenia, it is like they're trapped inside a world that does not exist. Schizophrenia is a reality-bending mental illness. Filled with distrust, suspicion, terror, and panic, schizophrenia fills a person's mind with paranoia, making them think that all those they love the most are out to get them. They become a prisoner of a world that is inside their head, where no one can get out of, where no one can escape, where they are left alone, vulnerable, and completely isolated. Which brings me to my second point. Timothy suffers from this terrible mental illness. Today, you will hear from two expert witnesses, Dr. La Greca for the prosecution, and Dr. Riley, the only expert who met Timothy Ray. And although the experts disagree with their conclusions, they actually agree on the medical facts of Timothy. You will see that both experts agree that there is evidence that Timothy exhibited symptoms of schizophrenia. You will see that both experts will reference the DSM, which is a manual used all around the world by psychiatrists in order to diagnose mental illnesses, including schizophrenia. Dr. Riley, the only expert that actually interviewed and met with Timothy Ray, will tell you that there is evidence of Timothy exhibiting the symptoms listed in the DSM. Whereas Dr. La Greca will tell you that he thinks Timothy is malingering. He will tell you that he came up with that conclusion without ever once meeting Timothy. In fact, today is the first time Dr. La Greca ever sees Timothy Ray. Finally, Timothy was not in his right mind on October 17th. This case is much more than just spilled juice. It is the morning of October 17th, 2018. There are scary voices living inside of Tim's head. He tries to fight them, but their volume is turned all the way up. Punish him. Punish him. Make him understand. Punish him. She's turning him against you. Make him understand. Punish him. Schizophrenia had taken over. Timothy grabbed a belt, put it around Nathan's neck, and Nathan was gone. Timothy was not in his right mind. Tim loved his son so much that he was fighting for custody of Nathan. He couldn't fathom a life without Nathan. Here we have a man whose wife has cheated on him, whose wife has left him, who only has Nathan, who is fighting for his son in order to build a life together, and then kills him? The state alleges that this was controlled and precise. They allege that this killing happened over spilled juice. When you're listening to the evidence today, remember, no one cries over spilled juice. No one kills their son over spilled juice. No man, no father, no reasonable person in their right mind kills over spilled juice. But this isn't about the juice. This is about schizophrenia. And schizophrenia is the reason why Timothy Ray deserves medical care in a hospital, not be warehoused in a prison cell. Help Tim get the help that he needs. Find the defendant not guilty because of his insanity.
Thank you. Before the state calls its first witness, I will ask everyone to switch to gallery view. That button is on the upper right of your screen. This will allow you to see the attorneys and witness at the same time. Okay. With that said, prosecution, you may call your first witness.
Your Honor, the prosecution calls off Detective Blake Booth to the stand.
Good morning, Detective Booth. You're constructively sworn.
Please state your name.
Hello, I am Detective Blake Booth.
Let's start with your background. Where are you from?
Well, I was born and raised here in Skelton, West Carolina.
What law enforcement experience do you have?
Well, I've been a law enforcement officer for 23 years. I started out in the gang violence and narcotics unit for 15, and then I became a detective for the last 8 years.
Now, Detective Booth, why are you here today?
I'm here to testify about what I learned in my investigation of Mr. Ray and him killing his son, Nathan Ray.
Do you see Mr. Ray in the courtroom today?
Yes, I do.
Could you please describe his appearance for us?
He is the Caucasian male wearing a white shirt and a blue tie.
Where in the room is he today?
He's constructively sitting next to the defense counsel.
Let the record show that Detective Booth has positively identified Timothy Ray as the defendant.
Shall so reflect.
Where does Timothy Ray reside?
He resides here in Skelton.
Who was Nathan Ray?
Nathan Ray was Mr. Ray's 6-year-old son.
I'd like to discuss the evening of October 19th, 2018. How did you get involved that evening?
I received a call from Officer Wentz at a sobriety checkpoint. He informed me that a person had been apprehended in connection to a missing persons report.
What did you observe when you first arrived on the scene that evening?
I found Mr. Ray handcuffed at the side of the road. I looked at his vehicle and I could see a dirt-covered shovel, bottle of bleach, large trash bags, and what appeared to be blood in his vehicle.
How would you describe the defendant when you met him at the checkpoint?
He wasn't very talkative. He made eye contact with me and his answers made sense, but he was very quiet.
Did he mention the CIA at all at this time?
No, not at all. He didn't mention anything out of the ordinary.
What happened next in your investigation?
At this point, we took the defendant to the police station to Mirandize him and then interview him.
I'd like to move the conversation to your interview with the defendant at the police station. How did his demeanor change when you started talking there?
He was very upset. He cried a lot and he shook during the interview.
How forthcoming was he during this interview?
He was very forthcoming. He told me everything that happened in about 20 minutes.
What did he tell you?
He told me that Nathan had spilled a glass of juice on his work laptop on the morning of October 17, 2019. He started yelling at Nathan, who ran to his bedroom. Mr. Ray wanted to punish Nathan, so he made him do jumping jacks, run in place, and do high knees. He informed me that he was unhappy with Nathan's exercise, so he went to his bedroom, grabbed his belt. He returned and hit Nathan with the belt, and in the end wrapped it around Nathan's neck and squeezed it until his son died.
What did he mention about the CIA during this interview?
Just before he told me he killed his son, he accused me of being in the CIA.
What was the last thing he said to you in this interview?
He said, "Blake, you said you would help me."
What happened next in your investigation?
The defendant informed me where he hid the body, so we went to go search in the Brandywine State Park.
I'd like to discuss what you found there. What did you see when you found Nathan's body?
After searching, we unfortunately found the body inside a black trash bag, buried in a shallow grave.
Did you take any photographs of the scene?
Yes, I did.
Your Honor, permission to approach the witness?
Yes, you may constructively direct the witness to the appropriate pages.
Thank you, Your Honor. And I'm constructively showing opposing counsel a copy of what has been previously marked as Exhibits 18 through 21. Detective Booth, do you recognize these exhibits?
I do.
What are they?
They're the pictures that we found, or the pictures we took when we found the body in Brandywine State Park.
Apologies, Your Honor. These pictures are on pages 95 through 98 of the case file.
That's okay. Thank you.
Do these pictures, are these a fair and accurate image of what you saw when you found the body in Brandywine State Park?
Yes.
Are these pictures in the same or same condition as the last time you saw them?
Yes.
Your Honor, the prosecution moves to admit exhibits 18 through 21 into evidence.
I think we took this up pre-trial. Defense, no new objections, right?
No, Your Honor, pursuant to your pretrial ruling, no objection.
Thank you. They're admitted.
Thank you. Permission to constructively publish these to the jury?
You may.
How are you able to identify that this was Nathan?
He matched a photograph that his mother had submitted when she filed a missing persons report.
Let's discuss what happened to Nathan Ray. Was an autopsy conducted?
Yes.
Your Honor, the prosecution seeks to judicially notice stipulation 4, which states that exhibits 6 through 8 are admissible.
Defense, is that accurate, or are these exhibits stipulated?
That's accurate, Your Honor.
Okay. So noticed.
Your Honor, at this time, the prosecution seeks to admit exhibit 6, which is the autopsy report on page 53 of the case file.
In its entirety?
In its entirety, yes.
Defense, do you wish to be heard?
I'm sorry, I want to make sure I heard that clearly. It was just 6 through 8?
Just exhibit 6.
Then no objection, Your Honor.
Okay. Then on agreement, exhibit 6 is admitted into evidence.
Permission to constructively publish this exhibit to the jury?
Yes.
Detective Booth, did you review this autopsy?
Yes, I did.
How did Nathan Ray die?
He was asphyxiated by strangulation, and the autopsy ruled it a homicide.
What efforts did you take to corroborate what the defendant told you about what happened to his son, Nathan Ray?
Well, after we obtained a search warrant, we were able to look through Mr. Ray's home and his cell phone.
Where did you find relevant evidence in Timothy Ray's home?
We found evidence relevant to this case in the kitchen, as well as Nathan's bedroom.
What did you find in the kitchen?
On the kitchen counter, we saw juice that was spilled.
What did you find in the bedroom?
We found a belt that Mr. Ray had described.
Your Honor, permission to approach the witness?
You may, constructively.
Your Honor, I'm showing opposing counsel exhibits 27 and 28 and showing these to the witness. These are on pages 104 and 105 of the case file. Detective Booth, do you recognize these photographs?
I do.
What are they depicting?
Exhibit 27 is the depiction of the belt we found in Nathan's bedroom. And exhibit 28 is the spilled juice we saw on the kitchen counter.
Are these a fair and accurate depiction of the scene as you saw it when you searched the house?
Yes.
Are these images, are these pictures in the same or substantially the same condition as the last time you saw them?
Yes.
Your Honor, the prosecution moves to admit exhibits 27 and 28.
Defense?
No objection, Your Honor.
Okay. Exhibits 27 and 28 are admitted into evidence.
Permission to publish these constructively to the jury?
Yes, you may.
Thank you. Did you conduct any other searches after searching the defendant's home?
Yes, after searching the home, we then searched Mr. Ray's cell phone.
What did you find on the defendant's phone?
We found a search history that happened the day after the incident, October 18th, that we found to be pertinent to this investigation.
Your Honor, permission to approach the witness?
Yes, you may.
I am showing opposing counsel a copy of what has been previously marked as Exhibit 10 on page 57 and showing this to the witness. Do you recognize this?
Yes, I do.
What is it?
It is a screenshot of Mr. Ray's cell phone and the search history he conducted on October 18th.
Is this a fair and accurate depiction of that search history when you first saw it?
Yes,
Is this image in the same or substantially the same condition as the last time you saw it?
yes,
Your Honor, we move to admit Exhibit 10 into evidence at this time.
Defense?
No objection, Your Honor.
Okay. Defense 10 is in evidence. I'm sorry.
Permission
Prosecution 10 is in evidence.
permission to constructively publish this to the jury?
Yes, you may.
Detective Booth, could you please read the 3 entries under search history on this image?
yes. Under Thursday, October 18th, it says countries that don't extradite for murder charges. How to get rid of a body. Will bleach destroy a body?
No further questions at this time, Your Honor.
Thank you. Defense, whenever you're ready.
Yes, Your Honor. Good morning, Detective Booth.
Good morning.
Now, you mentioned on direct that you interrogated Mr. Ray.
That is correct.
And during your interrogation, Mr. Ray asked if you were in the CIA.
Yes, he did.
He asked you twice,
That is correct.
even though he knew you.
That is correct.
Additionally, at least 6 times during your interrogation, he referred to they.
Yes,
He said, and I quote, "They told me she tricked him. They told me to do it. They told me to make him understand."
yes,
You never
Objection, Your Honor, to that previous question. Calls for hearsay.
Defense?
Your Honor, this is not hearsay because we're not offering it for the truth of the matter. We're not offering the truth is that anybody actually told Mr. Ray anything, but rather these are voices in his head, and that this goes to the credibility and the lack of follow-up Detective Booth took with her investigation.
Prosecution, I'll give you last word.
Your Honor, the theory of the defense's case is that there are voices in Mr. Ray's head that are speaking to him. Evidence of these voices is part of the truth of what he said there. He said, "They told me something, something, something." The they here are presumably the voices that he claims are in his head. And so this evidence is being brought in for the truth of the matter asserted that these voices were telling him to do things.
Okay, thank you. The objection's overruled.
Detective Booth, he asked you, or he told you, "They told me to do it. They told me she tricked him. They told me to make him understand." Isn't that right?
that's correct.
You never once asked him who he was referring to by saying they.
No,
And you thought this behavior was normal?
yes,
And at one point, there was a video of that interview, right?
that is correct.
But the police destroyed that video.
I wouldn't say destroyed. Our system after 30 days does re-go over the interviews because every interview that's conducted at the police station does get recorded.
So, Detective, it was deleted?
Unfortunately, after 30 days. However, I did receive a transcript of the interview.
So we agree, the video does not exist.
No, a transcript sufficed.
And you mentioned 30 days. You had a 30-day window to request to preserve it?
That is correct. I received a transcript, which is enough for my evidence.
But during those 30 days, you never requested the video itself.
No, I didn't think it was necessary for the video.
That was a choice you made, correct?
Correct. We had the transcript.
And that transcript, it can't show us what you said during direct, that he cried a lot.
Correct.
That transcript can't show us that he shook during the interview.
That is correct.
So we can't see what you saw from just the transcript, right?
No.
So let's talk about what you learned during those 30 days, okay?
Sure.
On the scene, Officer Wentz told you Mr. Ray was, quote, acting crazy and not making sense.
That is what Officer Wentz reported.
And in the 30 days before the video was deleted, you spoke to Mr. Ray's wife.
That is correct.
Jessica Ray.
Correct.
She told you, quote, I knew I should never left Nathan alone with him when he was acting strange. I knew he was going crazy.
Objection, hearsay.
Defense?
Your Honor, this is not hearsay. We are not offering it for the truth of the matter as to whether Mr. Ray was crazy or not, but rather the effect on the detective's investigation and her lack of follow-up.
Prosecution?
Your Honor, this is being used for the truth of the matter asserted. It's being used to demonstrate that there was a witness or a person out there who at the time knew or believed that Timothy Ray was acting crazy. While there may be some question as to the effect on the listener here in that line of questioning, it still is hearsay evidence because that line of questioning is dependent on this statement being true and therefore furthering an investigation.
Can I ask you, Mr. Levine, if I give the jury a limiting instruction that they are not to use the statement for the truth of the matter asserted, that they're not to conclude that the defendant was in fact crazy because his wife at some point said he was, but only to use it to determine what effect, if any, it had on the investigation and on the detective, does that cure the issue you have with the statement?
I don't believe it fully does. I worry that the statement knew he was acting crazy is too prejudicial and too strong a statement in this case to be heard directly by the jury. However, if you disagree with that line of reasoning, we would appreciate that limiting instruction.
Okay, defense, I'll give you one last word. Specifically, can you just explain to the court why the effect that this statement had on the investigation is even relevant?
Yes, Your Honor. The statement here is relevant because it goes to show that Detective Booth, during the 30 days she had to preserve the recording of her interview with Mr. Ray, she heard from multiple people that he seemed crazy or he was acting crazy in some sort of manner. She also witnessed during their interview that he was asking if she was in the CIA and he was talking about they. And yet, even after all of these interactions, she still chose not to preserve the recording of this video.
And I guess my ultimate question, though, is why is that relevant in your view? Why is the fact that she failed to preserve the video relevant at all?
Yes, Your Honor. It is extremely relevant for two reasons. One, it goes directly to her credibility and bias, but also, Your Honor, because this case is about an insanity defense, we have two experts that will be talking today, one for the prosecution and one for the defense. And the experts in this case never got to see that video to then interpret Mr. Ray's behavior during that interrogation and add that to their analysis. So it's extremely relevant.
Okay, thank you to both sides. I will permit the question and the answer. However, Mr. Levine, I will be giving the jury a limiting instruction constructively at this time to cure any potential problems of them using it for the truth of the matter asserted. Thank you. You may continue.
Your Honor.
Detective Booth, she told you, I knew I should never have left Nathan alone with him when he was acting strange. I knew he was going crazy. Isn't that right?
Yes, she did say that.
Now, Detective Booth, I want to understand this timeline. You testified on direct that Nathan was killed on the 17th.
That is what Mr. Ray told me.
And he explained to you that he put the body in his car.
Yes.
And then he drove around for a few days. Isn't that right?
Yes,
Mr. Ray was then arrested at the checkpoint on the 19th, right?
that is correct.
He even looked like he had been in his car for days.
Yes,
Now, his cell phone, that was recovered during the search of his home
that is correct.
after he was arrested.
Yes,
Now, I want to turn your attention back to Exhibit 10. You still have that in front of you, right?
yes, I do.
When this screenshot was taken, the phone was at the police station, right?
That is correct.
And this screenshot, if you look on the right panel, it shows the phone is connected to Wi-Fi.
Yes,
You would agree that since Mr. Ray was in custody at the time this screenshot was taken, he didn't connect his phone to Wi-Fi at the police station.
I guess so.
Objection, Your Honor, to that question. This calls for speculation and it's a question outside the knowledge of Detective Booth. We have no evidence as to Detective Booth's technical know-how and knowledge of the police station internet, if such Wi-Fi is or could be available. And therefore, this is a question getting outside the scope of Detective Booth's knowledge.
The defense, does the detective know the answer to that question?
Your Honor, the detective knows that Mr. Ray was in custody at the time this phone was searched. She just admitted during our questioning that the phone is connected to Wi-Fi. So the detective does know that at the time he was not the one who connected his phone.
Okay, overruled.
Detective Booth, in those 30 days, you also learned that the killing was over spilled juice on a laptop.
That is what Mr. Ray told me.
In those 30 days, you called Mr. Ray, and I quote, and please excuse my language, Your Honor, a piece of shit.
Yes, after he confessed to killing his son.
In those 30 days, you said that Mr. Ray would, quote, be better off dead.
I was a little passionate when I heard he killed his son, yes.
And because the interview, the recording was deleted, none of the experts in this case ever got a chance to see that video.
No, they had the transcript to review.
But not the video, correct?
Correct.
No further question, Your Honor.
Thank you, Ms. Boyer. Mr. Levine, any redirect?
No, Your Honor.
Okay, thank you. In that case, detective, you may step down. I will, at this point, permit, if the parties are interested, a time check.
Thank you, Your Honor. We would appreciate that.
Of course.
So conferring with the prosecution timekeeper, we have the prosecution at 37 minutes and 20 seconds left, and defense at 40 minutes and 22 seconds left.
Thank you. Okay, prosecution, you may call your next witness.
Thank you, Your Honor. The prosecution would call Dr. Mac LaGreca.
Good morning, Dr. LaGreca. You're constructively sworn.
Good morning, Doctor. Could you please introduce yourself to the jury?
Good morning. I am Dr. Mac LaGreca.
Dr. LaGreca, why are you here today?
I'm here to testify as to my medical opinion on Timothy Ray's mental state at the time of Nathan Ray's death.
Dr. LaGreca, I'd like to talk a little about your background and medical experience. What degrees do you have?
I have a Bachelor of Science degree from the University of Delaware, and after that, I received my Doctor of Medicine from the University of Pennsylvania, Perelman School of Medicine in 1989.
Dr. LaGreca, what did you do after graduation from University of Pennsylvania?
Your Honor, if I may,
I'm sorry, is there an objection?
If I may, the defense has no intent to object to Dr. La Greca being qualified as an expert in forensic psychiatry. So for the sake of time, if defense would like to go on to their next question, we are happy to stipulate that she is an expert.
I think the prosecution would like to have the jury hear about the doctor's credentials for credibility purposes, not just for certification. But your objection's noted, or your offer, I should say, is noted.
Thank you, Your Honor. Dr. La Greca, what did you do after graduation from University of Pennsylvania?
After completing my medical degree, I did my residency in general psychiatry at the UCLA School of Medicine. After that, I did a forensic psychiatry fellowship at the University of Pennsylvania.
You mentioned a fellowship. Where did your career take you after you finished your fellowship, doctor?
After I finished my fellowship, I owned my own private practice for 13 years, where I worked with patients with a variety of mental illnesses and mental disorders, including schizophrenia. After that, I sold my practice and moved to academia. Currently, in addition to my role as program director, I still treat patients once a week at the Jamie Spears Hospital.
Now, doctor, for those of us like myself who are unfamiliar with forensic psychiatry, can you explain to us more of what it is?
Forensic psychiatry focuses on the relationship between psychiatry and the legal system. Forensic psychiatrists provide services in criminal and civil matters where we provide opinions on mental health issues.
Doctor, what experience do you have working with patients that suffer from schizophrenia?
Over my 13 years of private practice, I worked with multiple patients with schizophrenia.
Dr. La Greca, have you testified as an expert before?
Yes, I have.
How many times?
7 times in criminal trials, 5 of which involved mental illness.
Doctor, do you hold any board certifications?
Yes, I hold 4 board certifications. I'm board certified by the American Board of Psychiatry and Neurology, and I'm also certified in 3 states, New Jersey, West Carolina, and Pennsylvania.
Now, doctor, what materials did you review in preparation for trial today?
I reviewed all of the records provided to me in this case, including Mr. Ray's interview and the police officer's accounts of Mr. Ray's behavior on the night of Nathan Ray's death. I reviewed the police report, the autopsy report, Mr. Ray's prison and military medical records, Dr. Riley's report, and Dr. D. Giuseppe's deposition.
Using these materials, were you able to form any medical conclusions about Mr. Ray?
Yes, I was.
We'll get to those conclusions in just a moment, but what methods did you use when drawing these conclusions?
I used techniques and practices that are relied upon in forensic psychiatry. I reviewed the relevant medical literature, including the DSM-5, and drew conclusions based on Mr. Ray's documented behavior.
Are these methods commonly used in your field to come to medical conclusions?
Yes.
Your Honor, I move to admit Dr. La Greca as an expert in the field of forensic psychiatry and schizophrenia.
Ms. Bustamante, do you have any objection to this certification of him as an expert? This is outside the presence of the jury. Just so the parties are aware, I'm not going to tell the jury that the court certifies him or does not certify him as an expert. However, you have met the foundational requirements for Dr. La Greca to offer her opinions to the court. With that said, knowing that I won't, bless him as an expert in front of the jury, Ms. Bustamante, do you have any issues with the doctor opining as to the psychiatric issues at play here?
No, Your Honor, we have no objection.
Okay. In that case, before we go back to before we bring the jury back in, the Dr. La Greca will be allowed to offer opinions within the purview of her expertise. Okay.
Thank you, Your Honor.
Back on the record, back in front of the jury.
Doctor, now I'd like to talk about the defendant, Mr. Ray. What can you tell us about his upbringing?
Mr. Ray was raised by his father, as his mother was not in the picture for almost all of his life. She left when he was 3. Mr. Ray's father has mentioned that his mother suffered from mood swings and was later institutionalized, but there was no formal diagnosis given.
Later in life, the defendant honorably served our country in the military. Was there anything noteworthy to you from this period in his life?
Mr. Ray enlisted in 2009, but he was discharged for other designated physical and mental conditions shortly after completing basic training.
What were those conditions?
Mr. Ray's officers thought he was struggling with difficulty sleeping, hallucinations, depression, and suicidal ideation, but Mr. Ray denied most of these things. He did confirm that he had feelings of depression, anxiety, worry, and trouble sleeping, but that was it.
Based on your review of the records, doctor, was he ever evaluated for these conditions?
Yes. Major Riley evaluated Mr. Ray and diagnosed him with generalized anxiety disorder, a very common form of mental distress. He concluded that Mr. Ray was not a danger to himself or others and prescribed him Paxil, a common medication for anxiety and depression.
After the military, was Mr. Ray able to find another career path?
Yes. Mr. Ray found a job at Computerland, which is a small computer repair company, starting in 2011. He was described as a fantastic employee who was never formally disciplined over 8 years of work.
Now, when you say never formally disciplined, were there any undisciplined problems or difficulties at work?
Objection, Your Honor.
My apologies. What's your objection, defense?
Will it be constructively be heard outside of the presence of the jury?
Yes.
The expert will be testifying to some improper character evidence of the defendant about a disciplinary measure that took place at work.
And can you offer, you give the court an offer of proof as to what you anticipate she will actually say?
I anticipate that the expert will be testifying to a time at work that Mr. Ray had a problem with another employee and they got into a physical altercation. This is improper character evidence.
Okay, prosecution, is that an accurate offer of proof? And if so, what is your response to counsel's objection?
Your Honor, in this case, we are simply trying to discuss we're not going to get into the defendant's character for violence under 404B. It's not character evidence, but rather modus operandi and how the defendant acts when challenged or presented with those who are working less than what he believes to be proficient.
May we be heard, Your Honor?
I'm not sure it's going to be necessary. Prosecution, why is his modus op? To the extent that you're right that it is modus operandi, why is that relevant? What about the instant facts at trial here today? Does that make any more or less likely?
Your Honor, in this case, we are simply trying to discuss if we're trying to say that these characteristics of the defendant having mental disease have been around for years, I presume that the defense will be going back in time to show instances where they believe he was showing instances of this mental condition, and I am highlighting this simply to illustrate lack of accident. When he's challenged, he reacts violently. In this case, when his son had an accident and performed less than he believed well, he then violently attacked his son.
Okay, I'm going to sustain the objection. It's skirting the boundaries of improper character evidence. I'm afraid that the jury, upon hearing that he had a violent episode in the past, might draw an improper inference about his conduct in the instant case. So I will sustain the objection.
Okay. Now, doctor, after his interactions with Major Riley, the defendant met with another doctor, Dr. DeGiuseppe. You reviewed her previous testimony?
Yes, I did.
When did Mr. Ray visit her?
Mr. Ray visited Dr. DeGiuseppe 3 times between 2010 and 2017.
What sort of observations did Dr. DeGiuseppe make?
Dr. DeGiuseppe never diagnosed Mr. Ray with any disorder. She never prescribed any medication. And this suggests that she felt Mr. Ray's mental state didn't warrant even the most conservative intervention.
Objection, Your Honor.
Yes?
Towards the response of the witness that Dr. DiGiuseppe never diagnosed the patient, Dr. DiGiuseppe was a general physician. She was not a psychiatrist.
Prosecution response.
Your Honor, if Dr. DiGiuseppe, in her previous testimony, did go into her evaluation of the condition of Mr. Ray in each of those visits, discussing that she didn't believe any intervention was warranted until later visits. I would say Dr. LaGreca, as she is in a unique position training the next generation of doctors, is in a position where she would be able to tell if Dr. DiGiuseppe would, as a general practice doctor, be able to tell if, while not able to diagnose schizophrenia per se, that the defendant was in mental distress.
Okay. I'm going to overrule the objection, but defense, you can feel free to cross-examine on this point and explore this territory as you see fit.
Thank you, Your Honor.
Doctor, what was Mr. Ray's condition in each of those visits?
During the first visit around 2010, after he returned from his military discharge, Mr. Ray described trouble sleeping and slight anxiety that was getting better upon being home. Dr. DiGiuseppe believed at that time that Mr. Ray just wanted some sleeping pills.
This next visit in approximately 2014, what was his condition then?
In 2014, Mr. Ray seemed a little bit depressed and anxious because there was some anxiety over a new baby that he and his wife were expecting. Mr. Ray's wife, Jessica, had told Mr. Ray that if he didn't get help, she would leave with the baby. He was very distraught about the idea of them leaving him.
You mentioned that he was very distraught. Can you tell us more about that?
Mr. Ray said, "I won't let them leave me, I just won't." And then he cried hysterically for a long time, and it took a long time for Dr. DiGiuseppe to calm him down.
What, if any, medical recommendations did Dr. DiGiuseppe offer at that time?
Dr. DiGiuseppe didn't prescribe any medication or recommend significant treatment, as she felt assured that he was not a threat to himself or others. Dr. DiGiuseppe believed that Mr. Ray was just going through a family situation.
What about this third and final visit?
Dr. DiGiuseppe thought Mr. Ray looked a lot worse then. Mr. Ray said that his wife was having an affair and that his wife was going to leave him. He got really angry when Dr. DiGiuseppe asked him if he was going to hurt himself or his family. He started screaming and called Dr. DiGiuseppe a bitch.
What did she recommend at this time?
Dr. DiGiuseppe recommended that Mr. Ray see a mental health professional and gave him a referral to a psychiatrist. She also noted that Mr. Ray denied suicidal ideation and didn't indicate at that time that he was going to hurt anyone else.
At that point, what did she recommend then?
At that point, she gave him a referral to see a psychiatrist.
That brings us to October of 2018. Did you come to any conclusions about Mr. Ray's mental condition in October of 2018?
Yes, I did.
What did you conclude based on your review of the record?
In my professional opinion, Mr. Ray did not manifest symptoms consistent with schizophrenia on or around October 18th, 2018. The behaviors and symptoms described don't fit the DSM-5 factors for schizophrenia.
Why did you conclude this?
From 2010 to 2018, Mr. Ray did not exhibit most of the symptoms of schizophrenia. There's no evidence in the record, either from Major Riley or Dr. DiGiuseppe's examinations of him, that he heard voices, hallucinated visually or auditorily, that he experienced delusions or had negative thoughts of any significance. He denied all of these symptoms to Major Riley in 2010.
What do you make of these voices he later described?
Voices that are indicative of schizophrenia are typically external sounds perceived by the listener as audible to everyone around them. Anxious thoughts, on the other hand, are one's own internal thoughts. In Mr. Ray's case, these were anxious or depressive thoughts. He said a voice told him that his wife was cheating on him. And as it turns out, she was. It makes sense that while he was anxious and depressed, he would be thinking about this. And that's not a hallucination.
How do Mr. Ray's other symptoms fit into your conclusion?
Mr. Ray had trouble sleeping, he cried a lot, and he had angry outbursts. He had trouble with grooming and personal hygiene. These are indicators of significant stress and anxiety. His wife was having an affair and she left him. So these behaviors are not surprising in the context of a man who was deeply hurt by his wife having an extramarital affair and leaving him.
What, if any other conclusions did you come to about Mr. Ray?
In my medical opinion, Mr. Ray showed signs consistent with malingering during his clinical interview with Major Riley.
Again, for those of us who are unfamiliar with these terms, what is malingering?
Malingering is when a patient is not truthful about their symptoms, often to create a legal defense.
Your Honor, may I constructively approach the witness?
You may.
I'm handing opposing counsel constructively a copy of Exhibit 17B on page 94 of the case file, as well as handing a copy to Dr. LaGreca. Doctor, do you recognize this?
Yes, I do.
What is it?
This is the DSM-5 definition of malingering.
Is this a fair and accurate depiction of the DSM-5 used in your profession?
Yes, it is.
Your Honor, at this time, the state would move to admit Exhibit 17B into evidence.
Defense?
We have no objection, Your Honor.
Okay, it's in evidence.
Thank you, Your Honor. Doctor, why did you conclude that Mr. Ray was malingering?
As a forensic psychiatrist, I'm trained in determining when a subject is trying to evade criminal prosecution. Malingering is more likely to occur when no other alternatives appear viable, such as here. There are 4 indicators of malingering in the DSM, and Mr. Ray showed 3 of the 4.
Let's discuss these indicators. What is the first one?
First is the medical legal context. This is a criminal case, and Mr. Ray is facing a very significant punishment.
And the second indicator?
Second is the existence of discrepancies between the person's claimed psychiatric disorder and the objective findings. Here, there are major discrepancies that exist. As I discussed, Mr. Ray did not show symptoms consistent with schizophrenia before he was apprehended by the police. There was a lack of symptoms in the written materials, medical records, and descriptions from those who knew him best.
What about this third factor?
The third factor is cooperation, and Mr. Ray was not cooperative in Major Riley's assessment.
Finally, doctor, what can you tell us about this fourth factor?
The fourth factor is the presence of antisocial personality disorder, which Mr. Ray does not have. The first 3 factors do suggest malingering.
Doctor, outside of these 4 factors, what, if anything, suggests malingering is an issue in this case?
Mr. Ray used language as if he was trying to fit the definition of schizophrenia when he was assessed by Major Riley after his son's death. Mr. Ray insisted that he was hearing voices, but not having intrusive thoughts. It's incredibly suspicious that he would know the distinction between these terms. Major Riley also noted several inconsistencies in Mr. Ray's account of what happened on October 17th. When a subject makes up symptoms, they often do so inconsistently.
Doctor, what conclusions did you make about Mr. Ray's mental condition in October of 2018?
In my professional opinion, Mr. Ray's condition was not consistent with someone who was suffering from schizophrenia, but I do think it's consistent with malingering.
Why did you come to that conclusion?
Mr. Ray was trying to punish his son. He believed that he was acting from a position of moral superiority. This would typically indicate an awareness of right and wrong.
Objection, Your Honor.
Yes, on what grounds?
Assuming we're being heard constructively outside of the presence of the jury.
Yes.
Pursuant to Federal Rule of Evidence 704 and the case law in this jurisdiction, Pascarello v. West Carolina, the witness is testifying to the ultimate issue in this case, whether or not the defendant was able to differentiate between right from wrong, and that is not permitted.
Prosecution?
Your Honor, under Federal Rules of Evidence 703, the doctor can testify about her conclusion and opinions based off of the evidence.
What's your response to defense counsel's argument regarding the Pasquarello precedent?
Your Honor.
I'm sorry, I'm addressing the prosecution.
Oh, I'm sorry. Where is this Pasquarello?
Defense, would you be able to direct us to the?
It's on page 14. I was able to find it, Your Honor.
Thank you.
However, Your Honor, an expert can testify as to the characteristics of a disease and opine as to whether the defendant had that disease at the time of the alleged criminal act, as quoted in Pasquarello on page 14. Defense,
I'll give you last word.
Your Honor, we have no problem with the expert testifying as to whether they believe Timothy Ray was suffering from schizophrenia at the time. We have no problem with that at all. Or whether schizophrenia could impede understanding right from wrong. But the line of questioning went along as to whether Timothy Ray was able to understand right from wrong, and that goes to the ultimate issue. And like I said, that is not permitted by 704 as well as Pasquarello.
I'll sustain the objection. I do think Pasquarello and Federal Rule of Evidence 704 prohibit this witness from opining as to whether or not this particular defendant had the requisite mental state for insanity. However, defense counsel is right. I will allow you to ask this witness whether or not, in her opinion, this defendant suffered from schizophrenia, and to the extent that she hasn't already, what the symptoms of schizophrenia are, including whether or not schizophrenic may or may not have difficulty understanding right from wrong, etc. However, she may not conclude as to whether or not this defendant had that mental state. So with that understanding and those parameters sustained.
Your Honor, if I may move to strike the previous answer.
Granted.
Thank you.
Doctor, you mentioned in your previous statements justifications that were offered. What sort of justifications did the defendant offer?
Major Riley asked Mr. Ray if he understood that what he did was wrong. Mr. Ray said, "I had to punish him." His answer suggests that he believed he was right to do what he did. He also indicated that he took time to calm down, and Mr. Ray still made the choice to kill his son.
What about Mr. Ray's actions after the killing?
Mr. Ray tried to hide the body. Hiding evidence is a hallmark indicator that a person realizes what they did was wrong. Mr. Ray sought ways to cover up his actions and to evade law enforcement.
No further questions.
Thank you. Defense, you may.
Thank you, Your Honor. Good morning. Good afternoon, Dr. Lagrega.
Good afternoon.
As of today, you've charged the government a total of $12,500 for your time spent in this case, correct?
Yes, that's correct.
And that is for your time prior to trial?
Yes.
And to sit here today, you're charging the government $1,750.
Yes.
And I'm not very good at math. This is why I went to law school. But if I'm right, that would be that you charged the government $14,250 for this case.
Yes, that's correct.
Now I'd like to go over what you reviewed for this case. You reviewed all of the police records in this case.
Yes, I did.
You also reviewed the transcript of Detective Booth's preliminary hearing?
Yes, I did.
So you're well aware that there is no video of the interview of Timothy Ray with Detective Booth?
That's correct.
That is the interview that took place 2 days after the Timothy Ray killed his son.
Yes, that's correct.
So you never got to watch this video?
I don't think anyone got to watch the video, to my knowledge.
And because you never got to watch this video, you weren't able to watch Mr. Ray's mannerisms in this interview.
Like I said, I don't think anyone was able to watch the video that I know of.
So you weren't able to watch his mannerisms in this interview?
Not during this particular interview, no.
You weren't able to watch or hear his tone of voice?
Not on video, no.
You weren't able to hear whether he was speaking really, really fast.
All I was able to see from that day were the transcripts of the conversations and the reports that I had reviewed from Officer Wentz and Detective Booth.
And because you were only able to see the transcript, that didn't show whether the defendant was speaking really fast.
I was not able to directly observe Mr. Ray on that day, but I did have access to the transcripts and the accounts from the officers from that day.
I know you had access to the transcripts, Dr. Lagreca, but I'm asking you whether you were able to hear how fast the defendant was speaking.
No, like I said, I wasn't able to directly observe him on that day. So that would imply that I couldn't hear how fast he was speaking.
Now, you would agree with me if I say that you weren't able to watch any of Mr. Ray's body language throughout that interview.
That's correct.
In determining whether a person suffers from schizophrenia, it is beneficial to conduct an in-person interview. Is that a yes?
Yes. If I'm the person making the diagnosis and evaluating the patient, then yes, I do want to conduct an interview if I'm able to.
It would even be preferable to conduct an in-person interview.
Yes, that's typically how I see my patients, again, when it's available to me.
You never got to see Mr. Ray before reaching an opinion in this case.
Objection, Your Honor. May we be heard outside the jury?
You may. Just what's the basis of your objection?
Your Honor, I believe counsel is about to go into a line of questioning about our expert not being able to interview the defendant. And per Fifth Amendment reasons, we're not allowed to get into the fact that the defendant chose not to speak with our expert. This could unfairly prejudice the jury in drawing that our expert was not able to meet with the defendant, and therefore her conclusions are less reliable.
First of all, is that what you're about to elicit? And if it is, what's your response?
Yes, Your Honor. We are about to go into a line of questioning of whether the expert had the chance to be able to interview the defendant. And in regards to the prosecution's argument, this is not a Fifth Amendment issue. This is a medical evaluation, and if the prosecution so desired to interview the defendant, have their expert interview the defendant, they could have issued an order for the court. There's nothing on the record that illustrates that. And yes, they submitted a request and we denied it. No order was granted. And this goes to the relevance and the credibility of the expert, which should be heard by the jury.
Okay.
Your Honor, may I be heard?
Yes.
It's directly in the case file that our expert did want to interview the defendant, and that the defense specifically refused our expert being able to interview her.
Okay. So it wasn't a constitutional issue, it was a matter of just the defense not permitting it. Is that accurate?
Right, yes, defense didn't permit it, but we're also not allowed to bring that up in questioning for his fifth.
I understand completely. So I will overrule your objection, but with the following caveat. Defense, you are permitted to ask whether or not this witness had an opportunity to meet with and personally evaluate the defendant. I do think that's something that the jury is entitled to hear about. However, if you do so, prosecution, on cross-examination, consider the door open and feel free to cross-examine as to the circumstances or her lack of ability to interview the defendant. Okay, so defense, proceed at your own risk, but you are allowed to ask the question.
Thank you, Your Honor. Dr. Lagreca, I'm going to re-ask my question. Did you ever have a chance to interview the defendant?
No, I did not.
But you didn't stop right there and tell the government that you couldn't write an opinion, did you?
As I stated earlier, it is preferable to perform a direct in-person interview with a patient, but that doesn't stop me from being able to evaluate a patient and their actions based on other documents and sources provided to me.
Exactly. That didn't stop you from charging the government $12,500 for an opinion in a case where you didn't interview the defendant.
As I said, it's preferable to interview a defendant, but that doesn't stop me from forming an opinion and being able to evaluate and critically analyze the situation based on my professional knowledge. So no, it did not stop me from charging the government because, as I said, I was able to perform my evaluation based on the documents and sources provided to me.
Now, you mentioned that you went over some documents to be able to form your opinion. You went over Dr. Riley's report, did you?
Yes, I did.
And in cross-examination, you mentioned that the defendant was uncooperative during this interview.
Yes, I believe I said that during my direct examination, yes.
Now, I just want to clarify. You went over Dr. Riley's report in order to conduct your analysis of the defendants, correct?
Yes, that was part of all of the materials that I reviewed.
Your Honor, I would like to refer the witness and the court to Exhibit 11 on page 61. That is Dr. Riley's report.
Okay.
That is the first paragraph under clinical interview with Timothy Ray. Now, Dr. La Greca, if you could please follow along silently with me as I read out loud. I met with Timothy Ray at my office for 3 hours on September 8th, 2019. Timothy Ray was cooperative throughout the interview. Did I read that correctly?
Yes, you did.
Thank you. You can put that aside. Now I'd like to go over some of the other documents that you reviewed in this case and some of the other reports.
Sure.
In 2010, Mr. Ray's commanding officer reported that Timothy Ray was seeing things, correct?
Yes, that was reported.
And seeing things that are not there is a hallucination, correct?
It can be.
Hallucinations can be a symptom of schizophrenia.
Yes, they can.
Lack of self-care can be a symptom of schizophrenia as well, right?
It can be a sign of a lot of medical diseases or just consistent with a person's values or beliefs, but it also can be a sign of schizophrenia.
So that's a yes. Inability to manage emotions can also be a symptom of schizophrenia.
Again, it's consistent with signs of a lot of other mental disorders, but yes, it can be a sign of schizophrenia.
Mr. Ray's wife reported that at times he would go days without showering. Is that a yes?
Yes.
Mr. Ray's wife also reported that he had issues with mood swings.
Again, mood swings can be a sign of other mental illnesses, but yes, she was concerned that he had mood swings.
Now, opposing counsel also went over some of the delusions that Mr. Ray went regarding his affair. I want to be able to touch upon that. Mr. Ray reported as early as 2015 that he believed his wife was having an affair.
I don't recall the exact date, but that sounds okay to me.
Now, with Dr. Di Giuseppe, he also reported that he thought his wife was having an affair, and that was, according to Dr. Di Giuseppe's reports, between either 2016 or 2017.
I'm sorry, can you repeat the question?
Timothy Ray, Dr. Di Giuseppe reported that Timothy Ray said that he thought his wife was having an affair as early as 2016 or 2017.
Yes.
But according to Jessica Ray's reports, the affair didn't start until 2018.
Again, I don't recall the exact date.
Well, you reviewed Dr. Riley's report, didn't you?
Yes, I did, but I'm sorry, I can't remember the exact date that was written in the report.
All right. We can agree that a delusion is a belief in something that is not real.
Yes, that's correct.
And if the affair didn't happen until 2018, then Timothy believed that something that was not real was happening as early as 2015.
I'm sorry, again, I don't remember if 2018 was the exact date that the affair began.
I think just to help the witness out, I think at this point, Ms. Bustamante is just asking you in a hypothetical way. If an individual believes then something that didn't take place until 2018 actually took place before that, would you agree that that is a, I don't want to misuse your words, Mr. Bustamante, but would you agree that that is somebody believing something that is not real?
Yes, if I'm following you correctly, I believe that if someone, a delusion is a belief that in something that is not real. So if you're saying that this was not real at that time, then it could be a delusion. Yes.
Okay, and I just want to make clear, I'm not purporting that that is what the evidence shows, but as a hypothetical, if that were the case, the witness has just answered that question in the hypothetical. To the extent that the jury feels that the evidence has not shown that the defendant believed that the affair took place prior to 2018, they can of course disregard that question and answer because it wouldn't be relevant.
Dr. La Greca, it is your testimony here today that you don't recall when the affair took place.
I know that part of it was happening in 2018. I just don't remember the exact date that she said the affair began.
Okay. I would like to refer you to page 73 of the record. That is Dr. Riley's report.
Okay.
Actually, I'm so sorry. That is Dr. La Greca's report. That is in paragraph 3. Actually, the paragraph that starts with additionally. Jessica Ray admittedly had an affair in 2018 with a neighbor. Did I read that correctly?
Yes, it says that she had an affair in 2018, but it doesn't say when the affair began.
All right, you can put that aside. This is your report, Dr. La Greca, right?
Yes, it is.
So you relied on the information that the affair started in 2018.
Again, I'm sorry, I don't recall it. I know that the affair happened and it led to marital issues within the Rays, and it was happening. Those issues were ongoing up until Nathan Ray's death, but I don't recall the exact date that the affair started.
Your Honor, at this point, I'm going to have to object, asked and answered, as well as argumentative.
Right, to the extent that the witness doesn't remember the exact date, I will ask Ms. Bustamante to move on.
Dr. La Greca, one last question. In basing your opinion, You solely relied on the same universe of facts that Dr. Riley relied.
I'm sorry, can you rephrase that question? Are you referring to my medical training or the DSM-5?
You only used the medical records of Mr. Ray. You only used the interviews that Dr. La Greca conducted. You only used Dr. La Greca's report. So my question is, did you only use the information, the same available information that Dr. La Greca had?
I used the same information that was made available to Major Riley, yes.
Okay, no further questions, Your Honor. Thank you.
Thank you. I'm sorry, Miss, I forgot your last name, Miss R. My screen only gives me the first initial of your last name. Prosecution.
Oh, yes, me.
I'm sorry, what's your
Erica Reaver, sorry.
Okay, I'm sorry, Miss Reaver. I don't like the fact that I have to keep referring to you as the prosecution, so I apologize for that. I misspoke earlier. To the extent that I allowed you to continue examination as to the issue of the availability of the defendant for Dr. La Greca's evaluation, I misspoke. I said you may pursue it on cross. What I meant is you may pursue it on redirect examination if you'd like to. By no means do you have to. So if you have a redirect, you may take it now.
Briefly, Your Honor. Dr. La Greca, is it typical for experts in your field to be paid for their time? Especially for testimony?
Yes, absolutely. I would say that most experts would not provide this work because if they weren't being paid, because our time is worth our money that we charge.
Now, Doctor, on cross, opposing counsel did go into a line of questioning about your ability to interview the defendant. Did you try to interview the defendant?
Yes, I did.
Why couldn't you?
The defendant was not available for me to interview.
Now, finally, this opposing counsel touched on some symptoms that they believe were indicative of schizophrenia, but inability to manage emotions, mood swing, etc. Can that be indicative of other mental conditions?
Absolutely, and they could be indicative of medical and mental conditions that Timothy Ray had been diagnosed with previously in his lifetime.
No further questions at this time, Your Honor.
Thank you, Dr. La Greca. You may step down.
Thank you, Your Honor.
Okay, to the extent that the parties would like a time check, I'll permit it. And then after that, prosecution, you may inform the court whether or not you have any additional evidence.
Your Honor, one moment. Okay, so we have then 2604 remaining for the defense and 2041 remaining for the prosecution.
Thank you very much. Okay, prosecution. Anything else?
Your Honor, at this time. Oh.
If I believe I may have left my video on. I'm having trouble turning it back on. I may have been kind of video muted.
I'm sorry, is that Mr. Levine?
Yes, it is.
Let me see if I can help you. We're all navigating these uncharted virtual waters these days.
Sure.
1 second. Can you try to turn your video on now? There you are.
Perfect. Could we judicially notice a stipulation at this time?
Yes, please just direct the court to where the stipulation may be found.
This is stipulation number 9 on page 5 of the case file. And it goes into some stipulated detail about the forensic analysis of the phone that is in Exhibit 10.
Okay. And you would like me to take judicial notice and constructively read it to the jury?
Yes, Your Honor.
Defense? Any objection to that, defense?
No objection. Your Honor, we have no objection.
Okay, thank you, Ms. Bustamante. Okay, the stipulation 9 is noticed and constructively read to the jury. Thank you. Anything further from the prosecution?
No, Your Honor.
Does the prosecution rest at this time?
Yes, Your Honor, the prosecution would rest at this time.
Okay. Before we take a short break, are there any matters that the defense would like to take up at this juncture?
Yes, Your Honor. At this time, the defense would like to make a mid-trial motion.
Okay, I'll hear your motion.
Pursuant to Federal Rule of Criminal Procedure 2009, we move for a judgment of acquittal, even viewing the facts and inferences in the light most favorable to the non-moving party, in this case, the prosecution. No reasonable juror could conclude beyond a reasonable doubt that the defendant, Timothy Ray, committed first-degree murder. The prosecution has failed to establish that Mr. Ray had the mental capacity necessary to be able to form malice aforethought. After showing their case with their expert having not been able to interview Mr. Ray, and the testimony of Detective Booth with the they and the mentions of the CIA, we show that Timothy Ray did not have the mental capacity necessary to be able to have malice aforethought or premeditated murder.
Thank you. Prosecution, would you care to respond to the motion the defense has just made? I believe they're only making the motion on the element of malice aforethought. So if you can limit your response to that element.
Yes, Your Honor. We believe that the prosecution has put forth sufficient evidence to demonstrate that Timothy Ray had malice aforethought at the time of the killing, and that a reasonable jury could, viewing evidence in a light most favorable to the non-moving party, could conclude that he had malice aforethought. We know that he killed his son after his son spilled a glass of juice. He then wrapped a belt around his son's neck and he squeezed until his son was dead. Then, in the coming days, he sought to hide his son's body and sought to search for countries in which he could flee to avoid extradition. This all shows that he had enough mental capacity to know what he had did, know that it was wrong, and know that punishment was coming. At the very least, all of this demonstrates that there is sufficient evidence for a reasonable finder of fact, when viewing this evidence in the light most favorable to the non-moving party, could come to that conclusion. And we believe that the evidence does not meet the burden for a judgment of acquittal.
Thank you. Having heard all the evidence and having heard both counsel's arguments, at this point I will deny the defense's motion, and we may proceed to the defense phase of the trial. With that said, we will take a 5-minute comfort break. It is a quarter to the hour, so we'll come back at 10 to. Okay, before we resume, I just want to make sure that all of the jurors are back. If each one of the jurors can just let me know that they're here.
Juror Freeman is back.
That's Carl is back.
I'm back, Your Honor. It's
Thank you.
Juror Dixon.
Thank you. And Ms. Feeney? Okay, so we'll just wait a moment for Juror Feeney to come back. Unless it's just a matter of technical issues.
Unmute.
Okay, there you are.
Okay, I'm here. Sorry.
That's okay, great. All right, so all the jurors are now back in the courtroom. Ms. Feeney, if you could just close your video once more.
Let me find my there. Oh, wait.
Thank you very much. Okay, are all the parties back?
Yes, Your Honor.
Excellent. Okay, defense, you may present your evidence.
Thank you, Your Honor. The defense calls Officer Wentz to the stand.
Officer Wentz, you're constructively sworn. You may begin.
Can you please introduce yourself to the jury?
Good afternoon. I'm Officer Peyton Wentz.
Good afternoon, Officer Wentz. What do you do for a living?
I'm a law enforcement officer. I've worked for the Skelton Police Department for the last 2 years, and I specifically work in their traffic unit.
All right, Officer Wentz. I'd like to shift our focus now to this case. How did you get involved?
I was a law enforcement officer working at a sobriety checkpoint on October 19th, 2018, and that is when we stopped the defendant in this case.
When you first saw Timothy Ray, what was your impression of him?
Well, initially, when I walked up to the window and made my first contact, things were just a little off, from the start. He was defiant, a little squirrely, but I also took note that he was disheveled. His hair was messed up. He had glassy eyes, and he looked pretty dirty. And there was a really strong odor coming out of the vehicle.
Officer Wentz, you mentioned that Timothy Ray was off and squirrely. Apart from his physical appearance, what was off about the defendant?
So as I said before, he was defiant, but he kept asking some really unusual questions. He was asking me if I was a member of the CIA, asking to see my credentials, kept saying things like the CIA was after him, at which point I thought it was really strange and unusual, so I asked him to get out of the vehicle.
What happened after the defendant got out of the vehicle?
So once I asked him to get out of the vehicle, he started doing something that was even more strange. He started doing jumping jacks, at which point I had to tell him to stop doing it. I asked him to stop. When he wouldn't comply, I drew my weapon and I asked him to stop again. But at this point, he stopped doing the jumping jacks, and then he switched to covering his ears and acting like he could hear something.
Officer Wentz, would you mind demonstrating how Timothy Ray was covering his ears?
Yes, ma'am. So it was kind of how you'd imagine a little kid who was trying to protect their ears, covered up the ears like this and just started thrashing his head around back and forth.
Officer Wentz, how did your interaction with the defendant come to an end?
So at that point, when I saw that his hands were back behind his head, I put my pistol back into its holster. I got over to the defendant and I was able to grab his arms and put them behind his back. I got handcuffs on him and was able to get him restrained. And then I sat him off to the curb, really until the other officers arrived on scene.
What other officers arrived on scene?
So when the defendant came through the sobriety checkpoint, his vehicle got flagged as a part of a be on the lookout for a missing person. Once that had gotten flagged back to dispatch, they notified the lead officer in that case, Detective Booth. He showed up on scene and he's who took control at that point.
Did you notify Detective Booth of the behavior that you observed at the sobriety checkpoint?
I did. I let them know exactly what I had seen, all of the observations that I had taken. I was a little surprised that an EMT didn't show up on scene because I thought that that might be appropriate for what was going on with him. But other than that, I told him what was happening and just waited for Detective Booth to give me any follow-on orders.
Once Detective Booth arrived to the scene, what, if any, was your role at that moment?
Right. So at that point, I was a supporting officer. So whatever Detective Booth needed me to do, I just followed their lead.
Thank you, Officer Wentz. No further questions, Your Honor.
Thank you. Prosecution, you may begin.
Thank you, Your Honor. Officer Wentz, I want to clarify some points you just discussed with opposing counsel. The night you met with the defendant was a rather boring night.
It was a sobriety checkpoint. It was a pretty standard night, I would say.
Until the defendant came through.
Yes, I'd never seen anything like what the defendant had done that night, no.
On direct, you described him as defiant when you approached him.
Yes, ma'am. He was a little reluctant, which actually isn't that unusual when, you run into a law enforcement officer. People don't necessarily want to comply, but he had some other pretty strange behavior as well.
Now, you mentioned this strange behavior. These strange questions didn't come up until after you had already received his license and registration, correct?
That's correct.
So after you return to his vehicle, he begins asking about the CIA.
Yes, ma'am, that's right.
When you are interacting with the defendant, before you have him get out of the vehicle, you saw something in the car that you thought was noteworthy in your report.
Yes, ma'am. There was a shovel, there were trash bags and bleach in the back of the vehicle.
You could see all of this just by shining a light in the vehicle?
Yes, ma'am, that's right.
So at that point, rather than you going to run his license and registration, you have your partner run it?
Yes, ma'am. Pretty standard protocol.
Out of safety concerns?
Yes, ma'am. So I could keep an eye on the defendant. He was acting really unusual.
Then you mentioned the defendant exiting the vehicle and doing a jumping jack.
That's correct, yes.
Now, officer, have you had any specific training on how to deal with individuals with mental health?
Yes, ma'am. I had a 40-hour training called the CIT program. They teach first responders how to de-escalate situations and really just how to make a scene more safe for everybody involved.
So when the defendant does this jumping jack, you pull out your gun, correct?
Yes, ma'am, I did.
Pulling out a gun generally doesn't de-escalate a situation.
It certainly makes sure that the individuals around are safe. And at that point, I was concerned for my safety, the other officer's safety, and quite frankly, for the defendant's own safety.
But pulling out a gun with someone in a crisis generally doesn't de-escalate.
Well, ma'am, I think it depends on what the situation is.
No further questions.
Thank you. Any redirect?
Yes, Your Honor, briefly. Officer Wentz, what behavior did you observe Mr. Ray have throughout your whole encounter with him?
Well, ma'am, as I mentioned before, it was something like I'd never seen before. Really, it was strange behavior from the beginning with the CIA questions, the jumping jacks, the covering the ears, just completely unusual from start to finish.
Thank you, Officer Wentz. No further questions, Your Honor.
Thank you, Officer Wentz. You may step down. Okay. Defense, you may call your next witness unless you need a time check, in which case I'll allow one. If not, then you can proceed.
We're ready to proceed, Your Honor. The defense calls Dr. Shane Riley to the stand.
Dr. Riley, welcome. Consider yourself constructively sworn.
Thank you, Your Honor.
Good afternoon.
Hello.
Please introduce yourself to the jury.
Hi, I'm Dr. Shane Riley.
What do you do for a living, Dr. Riley?
I'm a psychiatrist.
What is your educational background?
I went to Notre Dame, received my bachelor's there. Then I went to the University of Health Sciences, where I got my medical degree after which I went to Walter Reed and did a 4-year degree in general psychiatry. And then after that, I got a 1-year fellowship in forensic psychiatry.
Are you board certified, Dr. Riley?
Yes, I am board certified in general psychiatry.
What experience, if any, do you have in treating schizophrenia?
I've had, over the years of my practice, I've treated hundreds of patients with schizophrenia.
Have you ever published any articles on schizophrenia?
Yeah, I've published around 15 articles. 2 of those were about schizophrenia.
And have you ever been accepted in court as an expert?
Yeah, I believe over 20, probably like 25 times, yeah.
Your Honor, I tender Dr. Riley as an expert in psychiatry.
Okay, so the prosecution?
No objection, Your Honor.
Okay. So similarly, as I did with the prosecution's case, I will not certify or deem him an expert in front of the jury, but to the extent that you've established his credentials, you may ask him to opine on the issues relevant to this case.
Yes, Your Honor.
You may proceed.
Dr. Riley, how did you get involved in this case?
I was approached by the defense to talk about Mr. Ray and his medical conditions, medical and psychiatric conditions.
Were you able to reach any opinions in this case?
Yes, absolutely.
Do you hold all of your opinions to a reasonable degree of medical certainty?
Yes, I do.
And what is your opinion, Dr. Riley?
It's my medical expert opinion that he was suffering from severe schizophrenia.
Did you ever meet Mr. Ray before getting involved in today's case?
Yes, he was actually a patient of mine back in 2010. I interviewed him and spent about 3 days with him then.
And what materials did you review in coming to your opinion?
Along with the necessary court documents, I also interviewed friends and family of the defendant, as well as interviewing the defendant directly.
And are these types of information and materials something an expert in your field normally relies upon?
Yes, absolutely. I think interviewing the defendant directly and physically in the room is one of the key necessary pieces of evidence necessary in these types of matters.
Now, we heard from the government's expert today that Mr. Ray was malingering. Do you agree with that assessment?
No, I do not.
Why not?
So malingering is just based off the evidence that we have from my interviews and my with both the defendant, Mr. Ray, and his family. It's clear that these symptoms have been going on for a while, years, and that it just doesn't make sense that Mr. Ray would have the forethought of killing his son years in the making and basically make up these symptoms just so that he could one day get away with murder. It just doesn't make sense. It's much more likely that he had schizophrenia.
Dr. Riley, what did you base your assessment or diagnosis of schizophrenia on?
The DSM-5, which is the gold standard for psychiatry and for general psychiatry and forensic psychiatry.
Would you recognize an excerpt of the DSM about schizophrenia if I showed it to you?
Yes.
Your Honor, I am directing court and counsel to page 93 of the record. Also directing you, Dr. Riley.
Yes, absolutely.
Do you recognize Exhibit 17A?
Yes, I do.
And what is it?
It is the DSM-5 definition of schizophrenia.
Is this a fair and accurate copy of what you relied on for this case?
Yes.
Your Honor, I offer Exhibit 17A into evidence.
Prosecution, 17A.
No objection, Your Honor.
Thank you. It's admitted.
Dr. Riley, looking at 17A. Now, the jury is going to have a chance to look at this page during deliberations. Can you help us understand what is significant for you when diagnosing this condition?
So when I'm looking to diagnose any patient with schizophrenia, there's about a couple of different things I look at. Mainly, I want to see there's about 5 different things that usually present with schizophrenia. The recommended idea is that 2 of those things are present for at least a month. These 5 things are delusions, hallucinations, disorganized speech, catatonic or weird behaviors or and negative symptoms. In Mr. Ray's case, actually, he had 3 of these symptoms for about 4 years, not even months.
What 3 symptoms did Mr. Ray have?
He had delusions, auditory and visual hallucinations, and negative symptoms.
And did these symptoms occur for more than 1 month?
Yes, absolutely. These have been going on for years.
What were those delusions?
He was having auditory and visual hallucinations. He mentioned that he was hearing voices. One time he mentioned that he was hearing a creepy voice telling him to kill his son. His wife mentioned that he was also hearing other voices. And back in 2010, his commanding officer had mentioned to me that he thought he was speaking to someone.
Just to clarify, Dr. Riley, that was hallucinations, right?
Yes.
And did Mr. Ray report any hallucinations on the morning of October 17th?
Yes, he did.
What did he report?
Let me just, could you give me a second to remember?
Yes.
Yes, I understand now. He wanted me to, he reported that he was hearing a creepy voice that had told him that his wife had tricked his son into spilling the juice and tricked him into angering him, and also told him to kill his son.
Now, I want to turn your attention to the delusions you mentioned. What delusions did Mr. Ray have?
Mr. Ray had a specific subtype of delusions called persecutory delusions. He thought he was being followed by the CIA and that his wife was having an extramarital affair.
Now, you mentioned delusions about his wife's affair. We also heard that an affair actually occurred. How is that a delusion if she did have an affair?
I think after speaking with both Mr. Ray and his wife, the facts that I was able to obtain were that he started having this delusion, this paranoia, all the way in 2015, but the actual affair only started in 2018. So for about 3 years there, he had this delusion that his wife was cheating on him when in fact she was not, and that's a form of paranoia, which is consistent with a diagnosis of schizophrenia.
Okay. And you also mentioned negative symptoms. What were those?
There were a bunch of negative symptoms, but I think one that sticks out the most would be these mood swings.
And what mood swings did Mr. Ray have?
Sure. There were multiple reports of him, being very angry 1 minute and, crying and inconsolable the other. These kinds of erratic behavior patterns are also consistent with a diagnosis of schizophrenia.
Was there anything else you considered about diagnosing about Mr. Ray when forming your diagnosis?
There's also associated symptoms of schizophrenia. These things aren't necessarily directly causal or for a diagnosis of schizophrenia, but you tend to see these things with people who have schizophrenia, and many of those things Mr. Ray did have, such as not showering, no self-care, disorganized speech, increased tone, looking around weirdly, those kinds of things that I was able to examine in a direct interview during my direct interview with Mr. Ray.
Did anybody else report Mr. Ray had a lack of self-care?
Yes, both his wife did, and other members as well.
Now, let's address the prosecution expert. We heard from Dr. LaGreca earlier that Mr. Ray was faking the symptoms. How do you respond to this diagnosis of malingering? I think any psychiatrist has to consider the malingering when looking at a patient. It is good training to consider that, obviously, but I think there's things that I was able to obtain from my direct interview, like in the physical exam portion of my interview, just like how a cardiologist would listen to someone's heart and lungs to see how healthy they are. A psychiatrist looks at the tone of the voice, how fast you're speaking, are they making direct eye contact,
how organized is their thought content? Are they just rambling on? Or are they coherent? You know, how they're speaking. Those kinds of things are much more easily available and understood in a direct interview that I was able to obtain with Mr. Ray. And I was able to, because I had all of those, I had that direct contact, I was able to understand that this is actually schizophrenia and not malingering.
Now, you mentioned earlier that you actually met Mr. Ray back in 2010 when he was your patient.
Mm-hmm.
Well, we're all wondering then, why didn't you diagnose Mr. Ray in 2010 with schizophrenia?
So schizophrenia, the way it manifests in people is it's very chronic and it's very slow, and it kind of gets worse over the course of years. At the time in 2010, Mr. Ray, if anything, had only one of the 5 necessary pieces to diagnose schizophrenia. There was a brief mention of the commanding officer mentioning something about visual hallucination. But besides that, there wasn't really any further evidence. And I, at that time, no psychiatrist would have been able to diagnose him at the time. There just wasn't enough symptoms present in Mr. Ray at that time.
Would someone with severe schizophrenia be able to understand the wrongfulness of their actions?
Schizophrenia, by definition, when it's worse and severe like that, means that there's their sense of reality is not intact. That would definitely impair them from judgment and being able to tell right from wrong.
No further questions, Your Honor.
Thank you, Mr. Levine.
Yes, Your Honor. Serving overseas puts a great strain on our men and women in uniform, correct?
Yes, I would imagine it's very stressful.
You conducted a study on this exact topic, right?
Yes, it is one of many.
Many of our soldiers suffer from anxiety and mood disorders.
Among other diseases, yes.
Your study, however, didn't reveal any likelihood of schizophrenia.
My study?
Yeah.
Are you referring to the study that people in the military would have an increased likelihood of schizophrenia?
Your study that people in the military would have an increased likelihood of anxiety and mood disorders.
It did not.
Mr. Ray never served overseas.
Okay. Yes.
Did he?
He did not.
You've served as an expert witness 25 times?
Yes.
23 of those 25 times you served for the accused.
Yes.
Timothy Ray was a former client of yours?
Yeah, and I believe that gives me further insight as to his behavior and, just personal history.
You reduced your hourly fee by $100 for him.
Yes.
Because, as you just said, you knew him.
Well, he is a patient of mine, and I had that connection, and I understood what he was going through.
In 2010, Mr. Ray denied suicidal ideation and hallucinations?
Yes.
Officer Cruz mentioned these symptoms briefly.
Yes, he had reported to me and wanted me to check him out, see what's going on, and I completed a thorough and full examination of the patient on my own.
You were aware then of Officer Cruz's reputation for bending the truth?
I was not aware.
But you mentioned this reputation for bending the truth in your own expert report, didn't you?
Let me clarify. I was aware of the Officer Cruz's, but it did not affect my judgment in any way.
At the time, Mr. Ray said he was feeling anxious, depressed, and had trouble sleeping?
Yes, that is correct.
You diagnosed him with generalized anxiety disorder?
Yes. At that time, the symptoms that he was demonstrating were most consistent with a diagnosis of general anxiety disorder. And I do believe he's suffering from both at this time point, I believe he's suffering from both general anxiety disorder and schizophrenia.
I'm only asking about back then. That's a yes?
That is a yes.
And you prescribed Paxil, a common drug for anxiety disorders?
Yes, it is. It's an SSRI.
Mr. Ray, thank you. Mr. Ray met with Dr. DiGiuseppe 3 times between 2010 and 2017.
That is correct.
He never told her about any hallucinations? At that time?
He did not at that time.
She never found him to be a danger to himself or to others?
Yes.
I'd like to direct your attention to page 61 of your expert report. You said that Mr. Ray was paranoid about an affair with a neighbor, Pat,
Your
in
Honor.
2015.
Yes, what's the objection?
This is hearsay as counsel is testifying by reading directly off the report.
Mr. Levine, can you respond?
I was not reading directly from the report. I was saying that I was summarizing Major Riley's statement that the defendant was paranoid that his wife was having a neighbor in 2015. We also heard a great deal of discussion about that affair occurring in or being worried about in 2015 in direct. So this falls within the scope of evidence that is brought up in direct.
Thank you. Ms. Boyer, last word.
Your Honor, we have no problem with counsel asking these questions. However, he just directed the witness to his own report and then proceeded to read a line. So that would be hearsay.
Your Honor, if I may, I was not reading a line from the report. I was merely refreshing the witnesses, directing the witness's attention to there. If I did wind up speaking using language that was in there, that was not intentional.
Okay, fair enough. I'm going to overrule the objection. You may proceed.
No, Major Riley, you said that this worry about an affair turned out to be true?
Years after.
I'd like to draw your attention to, actually, never mind. Let's move on. You met with Mr. Ray on September 9th, 2019.
Yes, I did.
Then he claimed that he heard a voice telling him to kill his son on October 17th, 2018.
I believe that is true.
He didn't tell you that he beat his son.
He did not.
He told you that he strangled his son in the kitchen.
Yes, he did.
He told you that he had to do it.
Yes, he said they told me to do it.
He also said that he had to do it. That was language that he used?
Yeah, I think in the context of the conversation, I understood that as they, being the voices in his head, were pressuring him to do it.
He said that his son is in a better place now away from his mama and papa?
I believe those were his words.
He told you that he was worried about going to jail.
Yes, he did.
That he knew he was going to jail for what he did.
Yes, he did.
You interviewed his father, Abe Ray?
Yes.
Abe Ray never observed anything out of the ordinary with his son.
As is in the case with most people suffering from mental illnesses, there is a stigma associated with mental illnesses, and there's a very high likelihood that Mr. Ray did not want to be seen as someone with mental illness and might have hid that from his family. I'm not sure.
I believe Abe Ray was shocked to hear that Mr. Ray had killed Nathan.
I imagine any grandfather would be shocked.
You cite Mr. Ray's family history as suggesting he could be at risk for schizophrenia?
Yeah, there's a lot of evidence suggesting that there's a family history component to mental illnesses, to all mental illnesses, not just schizophrenia.
You spoke with Abe Ray for 10 minutes.
Yes.
You've only testified at trial once before this, correct?
Yes.
You testified for the defense?
Yes.
You said that there is a much higher likelihood of malingering in murder cases at that trial, correct?
There is a much higher. I believe most patients who I see, about 82% of the time, they're not malingering. About only around 18% of the time, which is high, but not the highest likelihood.
But at that trial, you did testify that there is a much higher likelihood of
relevance as to what Dr. Riley testified to at a separate trial. This can only lead to confusing the jury.
Mr. Levine, I'll allow you to ask the question, but don't delve any deeper into the prior trial.
At that trial, you testified that there is a much higher likelihood of malingering when, yes.
Yes.
No further questions, Your Honor.
Thank you. Ms. Boyer?
Dr. Riley, in your experience, how often does schizophrenia go undiagnosed?
It goes undiagnosed for months and years. It's one of the biggest issues we have when dealing with mental health issues, that oftentimes individuals don't seek help right away, and these symptoms fester and get worse over time, often making the diagnosis and the prognosis for these patients more troublesome years later.
No further questions, Your Honor.
Thank you. Thank you, Dr. Riley. You may step down.
Thank you, Your Honor.
Okay. Is there any more evidence from the defense?
At this time, Your Honor, the defense rests.
Thank you. Before we proceed to closing arguments, any further motions from the defense?
I believe my co-counsel will be giving our motion.
Yes, thank you.
Yes, Your Honor. At this time, we would like to renew our mid-trial motion for motion of acquittal. Again, looking at the facts and evidence in the light most favorable to the non-moving party, in this case, the prosecution, no reasonable juror would find that beyond a reasonable doubt, the defendant had the mental capacity necessary for first-degree murder.
Thank you. Prosecution, I'll give you a chance for a quick rebuttal.
Your Honor, we would like to raise a quick concern that this misstates the law. The burden is beyond a reasonable doubt that the defendant had the mental state, the mens rea capable of malice aforethought. Whether he was capable of forming that is a question of his temporary insanity, and the burden on that is a question of clear and convincing evidence that must be met by the defense. He has been found competent to stand trial in a pretrial motion, so he was then found to have the capacity for malice aforethought. Beyond that, we believe that the evidence that has been presented today certainly meets the high bar required to deny a judgment of acquittal. We know that he killed his son. We know that he hid his son's body. We know that he tried to evade prosecution. And we know that he took a moment after punishing his son, to go to his room, get a belt, think about what he was going to do, and then proceed to do it. This all shows that a reasonable jury could believe that he possessed malice aforethought at the time that he killed his son.
Thank you. I'll deny the motion at this time. Okay, we're ready to proceed to closing statements. Before we do so, I think a time check is in order. Can we please have one?
Yes, Your Honor. We have 11 minutes and 25 seconds left for the prosecution and 9 minutes and 51 seconds for the defense. And a point of clarification, Your Honor, should either side go over this time limit, would you want the opposing counsel's timekeeper to announce that, or would you just like that to be noted later?
Unfortunately, I've been instructed that the governing rules of this jurisdiction call for a hard stop once an advocate has reached his or her time limit. So if that occurs, I hope it doesn't, but if it occurs, if one of the advocates does reach their allotted time limit, yes, opposing sides timekeeper should at that point make themselves visible and notify the court. Please do so respectfully, but do that. Notify me when the time limit has been reached. Okay, is that understood by everybody?
Thank you, Your Honor.
Okay. I'm sorry, was there a question? Mr. Levine, you're muted.
Yes, Your Honor. That's understood. I was wondering if it would be possible to either ask some of the timekeepers to provide warnings at certain intervals, or for the advocates to set up timers on their own end. If these things are outside the rules, I understand completely. I just wanted to check.
I don't think your first suggestion is outside the rules. So I think that's a good suggestion. Would the timekeeper please provide the advocate with a 2-minute warning?
Certainly, Your Honor.
Yes, Your Honor.
Okay, excellent. All right. That said, do the parties need any time to prepare for closing statements, or can we begin?
Yes, Your Honor, we'd like 5 minutes, if that's all right.
Okay. You may take the 5 minutes. While you do that, I just have a statement that I need to now read to the jurors. We will now, soon, within the next 5 minutes, hear closing arguments from each party. Everyone should please switch back to speaker view. Thank you. All right. So we're back in 20 minutes at the half-hour mark.
I'm sorry, Your Honor, 20 minutes or 5?
You're right, 5 minutes at the half-hour mark.
Thank you, Your Honor.
Okay, are the parties ready?
Yes, Your Honor.
Prosecution?
Yes, Your Honor.
Okay. Prosecution, when you're ready, you may begin.
May it please the court, opposing counsel, members of the jury. At the beginning of this trial, my co-counsel, Erica Reber, described the cold, calculated precision with which Timothy Ray choked the life out of his son, Nathan Ray, and told you the sad story about how in Skelton this year, there will be one fewer trick-or-treater on the streets. The burden of proof in this case is that of reasonable doubt. And we, the prosecution, believe that we have met this burden of proof and proved both elements beyond a reasonable doubt. We have proved that Timothy Ray caused the death of Nathan Ray. The defense has admitted that this is not truly in dispute here. We know that this happened. We also believe that we have proved that this has been done with malice aforethought, that it was premeditated or done with a callous and wanton disregard for human life. Now, reasonable doubt is a difficult phrase. You're always going to have some doubt about just about everything. But here, what that means, is your doubt reasonable? Is it something that you think a reasonable person would have? Does it go beyond just a little shadow in the back of your mind? And we believe we have met both of these elements beyond a reasonable doubt. Timothy Ray got angry when his son spilled a glass of juice. He took him to the bedroom. He made him exercise. Then he did something very important. He went back to his bedroom. He got a belt. He thought about what to do next. And he chose to go to Nathan Ray's room, beat him with that belt, and kill him with the belt. This shows premeditation. Premeditation does not require a long and extensive plan and days of preparation. It can form in an instant. It merely requires that the act is intentional or willful when he kills his son. And even if you don't believe premeditation is here, what could be more callous and show a more wanton disregard for human life than wrapping a belt around the neck of your own son and squeezing until he is dead? Now, the defense in their opening has said that this couldn't have been what happened, because what father would do this to his own son? Timothy Ray. And if you believe we've met this burden, you then have a difficult task in front of you. You have to wrestle with the elements of the affirmative defense of temporary insanity. This is an affirmative defense. The defense must meet this burden by clear and convincing evidence. They must show that he suffered from a severe mental disease or defect at the time, and then the important part, that he was unable to appreciate the nature and quality of his acts, or that he was unable to appreciate the wrongfulness of what he was doing, considering whether it was contrary to generally accepted standards of right and wrong. You may consider his understanding that it was against the law. Essentially, did Timothy Ray know what he did? And did Timothy Ray know that it was wrong? He knows what he did. He told Dr. Riley that he knew he was going to jail for what he did. And he wanted Nathan to be in a better place away from Mama and Papa. He wanted to do this. Furthermore, he knew it was wrongful. He knew after doing it, he had to hide. He tried to hide the body. He tried to escape the country, or at least look into that. He knew what he did, and he knew it was wrong. A lot has been heard about Timothy's mental health today, and mental health is certainly an important issue at this trial. But make no mistake, the question for you at this trial is not, did Timothy Ray have schizophrenia? That may be important, but that is not the question. The question is, did Timothy Ray know what he was doing when he killed his son? And did he know it was wrong when he killed his son at that time? Let's look at all the mental health evidence we've seen, and let's divide it in two. There's everything that Timothy Ray went through and reported and suffered before the murder, and there's everything that he's claimed has happened since then. Before the murder, he was diagnosed with generalized anxiety disorder. He had depression, trouble sleeping. He had valid concerns about his wife and kid leaving him. His wife and kid did leave him. These concerns were not delusional. Millions of people around the world worry about their spouses cheating on them. If it turns out that a spouse cheats a little later than that, Were those concerns delusional to the point of being a mental health issue, a severe one? And furthermore, we've heard that Jessica Ray had an affair in 2018. We've heard no evidence that she didn't have any affairs before that. There's no diagnosis of a severe mental illness before 2018 and no documented hallucinations or delusions. After he kills his son is apprehended, he's accusing people of being the CIA. He thinks the CIA is after him. He thinks there's a camera and a microwave monitoring him. And most importantly, he thinks he's going to jail for what he did. We heard from Dr. LaGreca. Dr. LaGreca testified about malingering. There are 4 factors to consider in malingering. And Dr. LaGreca says that we see 3 of them here. The first is the criminal context. Evidence shows that Mr. Ray behaves differently when there's a threat of punishment. When he's stopped by the cops, he seems okay until he has to, squirrely, defiant, but all right. Then he has to hand over his ID and he's doing jumping jacks and acting much differently. Another sign, the second sign here, are the discrepancies. He killed his son in the bedroom, but he told Dr. Riley it happened in the kitchen. He said once that it happened right away and later that he paused to think about it. All his life, he denied hallucinations and suicidal ideations. Then he kills his son and he suddenly had these things for years and years. Third, he was not cooperative. Lingers try to appear hostile and questioned. Think about the night that he was apprehended. He's defiant. Then he's energetic and doing jumping jacks. Then he's quiet. Then he's sobbing and telling everything. Then he's not talking again. He goes back and forth, showing a lack of cooperation at times that night. Dr. LaGreca concluded that Mr. Ray's behavior is of someone who is trying to look schizophrenic. Dr. LaGreca studies this very topic and concluded Mr. Ray was trying to sound as if he had these symptoms. Major Riley has come to the opposite conclusion, but he admits that Mr. Ray could be malingering, and his diagnosis is based on these hallucinations and these delusions. These hallucinations, again, we have no documentation that those were done. Those happened ahead of time or before 2018. And the delusions here, we're basing an entire possibility of schizophrenia on the fact that a man who was worried about his wife cheating him had a wife that did cheat on him. Maybe Mr. Ray was more worried than he should be back in 2015, but he had reason to be worried. This does not rise to the level of delusion. And a lot has been made about Dr. LaGreca's opinion based on the lack of interviews and inability to interview Mr. Ray. Now, as you heard today, Dr. LaGreca tried to interview Mr. Ray. Mr. Ray and his counsel would not allow that interview to happen. And now they're saying that this lack of an interview.
There has been no testimony today about the fact that defense did not allow Dr. LaGreca to interview the defendant. And this is impeding the line on Mr. Ray's Fifth Amendment right.
I remember the testimony differently on redirect examination. To the extent that I'm wrong, the record will control, as will the jury's recollection. Overruled.
Yes, Your Honor.
Thank you, Your Honor. Now the defense is trying to say that the lack of an interview is proof that Dr. LaGreca's opinion is invalid. Remember that the burden here is on the defense to meet the temporary insanity elements. If there's evidence here that they say needs to be there and isn't there, that hurts their case on that point. The same thing extends to that interview and video of that interview. Maybe that would have helped their case. Maybe it would have hurt their case. But that is evidence that they need to meet their case. The burden is on them. Let's discuss what happened to Nathan Ray. Nathan Ray spilled a glass of juice. And at the opening of this case, the prosecution said, no one cries over spilled juice. Or excuse me, the defense said, no one cries over spilled juice. Nathan Ray did, because he knew what was coming. He knew his father gets angry when things are out of his control. The defense said no father kills his son over spilled juice. Again, Nathan Ray was killed because of the spilled juice. and Nathan's Ray's reaction shows he knew what was coming. We heard that Timothy Ray has worked successfully in the workforce for 8 years without any problems. This shows that he can behave when he wants to, but on October 17th, 2018, he didn't want to. He wanted to control his son for misbehaving. He knew what he did was against the law. He knew what he did was wrong. That's why he was so worried after the fact. That's why he tried to hide what he did. And that's why he's here trying to get away with it now. With this insanity defense, he's still trying to get away with it. At the end of this trial, when the judge instructs you on the law and how to apply it, we need you to come back with a guilty verdict. Nathan Ray needs you to come back with a guilty verdict. Punishment and justice demand that you find Mr. Ray guilty. Don't let him get away with it. Find him guilty.
Thank you. Okay. Before we begin with defense's closing argument, can a timekeeper please let Mr. Levine know how much time prosecution has for rebuttal?
Yes, Your Honor. We have 1 minute and 5 seconds for rebuttal, and that was confirmed with the prosecution. So
excellent. Thank you very much. Okay. With that, defense, you may begin.
Timothy Ray was not in his right mind on the morning of October 17th, 2018. Because no father, no parent, no person in their right mind would kill their son over spilled juice. Unlike the prosecution, who has the highest burden of beyond a reasonable doubt, we have to prove to you only by a lower standard of clear and convincing evidence. This is not the same burden as the prosecution wants you to believe. We only have to prove to you that it is highly probable that Timothy was suffering from a mental disease and he did not understand the wrongfulness of his actions. And we have done this for 3 reasons. First, schizophrenia is a reality-altering disease. Second, Timothy suffers from schizophrenia. And third, Timothy was not in his right mind on October 17th. So let's start with that first point. Schizophrenia is a reality-bending mental illness. You heard from both experts today who agreed about what the symptoms of schizophrenia are. How when somebody suffers from this mental illness, they often cannot understand the wrongfulness of their actions. It's because there's a disconnection between what is real and what is not. The experts agreed about the symptoms and the effects of schizophrenia, but it's what they disagreed about that brings me to my second point. Timothy suffers from schizophrenia. Dr. Riley, the only expert you heard from today who has personally treated Timothy, he explained how Timothy exhibited signs of schizophrenia for a length of time well beyond what's required in the DSM. How because his illness went untreated, it progressed and worsened. Now, the government paid top dollar for their expert today, and yet Dr. LaGreca couldn't remember the facts she relied on. She couldn't even remember the facts that she wrote in her own report. So how did Dr. LaGreca arrive at an entirely different opinion, considering she never met Timothy, never evaluated in person, never got to see his body language, never got to interact? Considering she admitted today that when she's making a diagnosis, it's preferable to interview that patient in person. Considering they both relied on the same facts. Think about it this way. Both doctors are looking at something with feathers, webbed feet, and quacks. Dr. Riley concludes he's looking at a duck. While Dr. LaGreca concludes she's looking at an airplane.
Objection, Your Honor.
Overruled.
Members of the jury, it's because Dr. LaGreca ignored the facts. Dr. LaGreca ignored Timothy's delusions about his wife's affair because Jessica did have an affair. Only this was 3 years after the delusion started. You even heard from Dr. LaGreca that if the paranoia started before the affair began, it would be a delusion. She discounted Timothy's negative symptoms because mood swings and a lack of hygiene on their own don't indicate schizophrenia. But Dr. LaGreca's reasoning is just as unsound as Timothy's mind. Because to diagnose schizophrenia, you have to look at all of the facts as a whole. And that's exactly what Dr. Riley did. Because Dr. Riley based his conclusion on all of the facts and objective observations from before, during, and after October 17th. The symptoms didn't just start the night he was pulled over, as the government wants you to believe. As early as 2010, Timothy's commanding officer reported he was seeing things and sleepwalking. Timothy's wife, the woman who spent every day with him, was there when he woke up, was there when he went to bed. She knew. She knew there was something wrong for years. She saw his mood swings, saw his lack of self-care, and pleaded for him to get psychiatric help.
Objection, Your Honor. This is going over the line established by the previous hearsay objection and limiting instruction as to Jessica Ray's comments on Mr. Ray's mental state.
How so? Ms. Boy, are you using these statements for the truth?
No, Your Honor. And this is also regarding Dr. Riley's testimony as to what his wife reported to Dr. Riley, not what counsel is suggesting.
Okay, the jury has been already instructed. They will, I assume, follow my instruction. Your objection is overruled.
She knew and was pleading for him to get psychiatric help. And when Officer Wentz interacted with Timothy, she was immediately alerted to Timothy's schizophrenic symptoms. She saw Timothy talking to himself, saw him holding his head, trying to keep the voices out, saw how dirty and unclean he was. These are all clear signs of hallucinations, delusions, and negative symptoms. 3 of the DSM criteria for schizophrenia when all you need is 2. Which brings me to my third and final point. Timothy was not in his right mind. You heard about the creepy voices in Timothy's head that morning. They told him to punish his son. They told him his ex-wife was trying to trick him. Timothy did not know what he was doing. He couldn't understand right from wrong. He was not himself. He was his disease. And his undiagnosed schizophrenia took Nathan away forever. He just wanted Nathan to understand. And the government has offered no credible argument on motive here. What motive did Mr. Ray have to kill his son? Spilled juice? A broken laptop? Why would a father who had nothing left but his son then kill him? We also have to look at credibility, because time and time again, Detective Booth showed us her bias. Detective Booth had 30 days to preserve the video recording of her interrogation. She had plenty of opportunity and reasons to do so, but she still chose not to. Even though she heard from Officer Wentz and Timothy's wife that he seemed crazy. Even though Timothy told the detective about the voices in his head and asked the detective about the CIA. Anyone observing Timothy would have been alerted to his symptoms, and a detective with 23 years of experience should have been alerted, should have preserved that video. And because Detective Booth destroyed that video, the experts in this case couldn't see it. They couldn't see his body language or hear his tone, and you, members of the jury, You couldn't see that video either. Then, of course, there's this issue with all these phone searches. And again, we have to look at credibility because you might be thinking these are pretty bad, but they might be if they were real. On October 17th, Timothy strangled his son, put the body of him in the car, and drove around for a few days. And October 19th, he was arrested, still on the road.
Your Honor, if I may object. I would like to object to that statement as to the reality of the phone search. It has been stipulated and entered into evidence that the forensic analysis was conducted, and that analysis showed that on a certain date, 3 Google searches occurred as reflected in that exhibit.
I don't think that's what Ms. Boyer was arguing specifically. Overruled.
We know that on the 17th, Nathan was killed, put in Mr. Ray's car, and on the 19th, Mr. Ray was arrested at the checkpoint, looking like he had been in his car for days. His cell phone wasn't found on his person. It wasn't found in his car. It was found at his home after arrest. How would Mr. Ray make these searches if he was not with his phone? When his phone was at home while he was driving around in his car for days. The simple answer is that he didn't and couldn't have made those searches. So who did? Well, we know that the phone was connected to Wi-Fi at the police station. But why? To fabricate these searches? We don't need to know who did it, how they did it, or why. All we need to know is that Mr. Ray did not have his phone on October 18th, and he could not have made those searches. The government wants you to trust Detective Booth, a man or a woman who called him a piece of shit who should be dead. Does that sound like an officer you can trust? This is my last opportunity to speak with you, members of the jury. So I leave you with this. How could Timothy have controlled, calculated, and precisely displayed symptoms of schizophrenia for 10 years? You must find Timothy Ray not guilty.
Thank you, Ms. Boyer. Mr. Levine, I believe you have 1 minute and 5 seconds remaining if you choose to use it for your rebuttal.
We do, Your Honor. This cell phone was searched on October 18th. Both parties agree to that. Mr. Ray was apprehended on October 19th, and the defense claims this means that on the 18th, the police were somehow doing these searches. These are the straws that they're grasping at. They want you to believe that schizophrenia means temporary insanity. If he has schizophrenia, he's not guilty. That is not the case here. The job is for you, the jury, to use your common sense and answer 2 questions. Did he know what he was doing? And did he know it was wrong? Schizophrenia didn't kill Nathan Ray. Timothy Ray did. And as to motive, Nathan Ray was screaming for his mother, and this angered Timothy Ray, because he was angry at his wife for leaving him, and he heard his son screaming for his wife, and he killed him. They say no father in his right mind would kill over spilled juice. This father did. Find him guilty.
Thank you, Mr. Levine. Okay, that concludes the trial. Thank you very much to all of the participants. Before we do anything else, let me just read the following instruction. Judges and jurors, please complete your ballots now. I need to ask everyone to stay on until everyone has submitted their ballots. And once all ballots are submitted, we will do brief comments, before which I have to do another announcement. So jurors, please complete your ballots. And once you've completed them, please give me just let me know that you have. Thank you, Juror Feeney. I got your message that you're done. Juror Freeman, thank you. Juror Dixon, thank you. Okay, I think we're all set. Right, Juror Cole, just want to confirm. Oh, I think I just got the message. Yep, got it. Okay, thank you so much. All right, let me read my last comment that I have to read, and then we can begin. All the ballots have been submitted. We will do some brief oral comments now for the attorneys only. Because we have so many judges and we want to give the attorneys time to prepare for their next trial, I will ask each judge to limit themselves to one comment only, either their favorite moment from trial or one suggestion for one of the competitors. Okay, that said, jurors, you can make yourselves visible and we can begin with comments. Who would like to go first?
I'll go first. Well, can you hear me?
Yes, loud and clear.
Okay, so first of all, I want to congratulate everybody, but for my one quick comment, I think what I like the best is an overall theme that I like the best when I am in a trial, involved as a litigant or observing, and that is short, to the point, and not beating a horse. And I think who did that pretty effectively was Taryn in her cross when she was in the prosecution case. So I guess that's just my because this was a 2-hour affair and jurors can sit for days, weeks, and months. So that's my thought process. Thank you very much. It was a pleasure to listen to all of you and do all of your hard work.
Thank you very much.
I guess I can go next. I teach mock trial, so I know whatever suggestions your coaches are going to tell you to ignore. I understand that everyone has their own style. I really appreciated how this trial was done. I'm personally a criminal defense attorney, so my only criticism, and I don't even think this is a criticism, I don't know if it was constructive that you were going through the evidence. Was there a reason why it wasn't displayed to the members of the jury? Because you were referencing a lot of these things, and I would have liked to see what some of these exhibits were as you were being crossed, as you were being directed on that. And I don't know if that's something that the competition said don't do, but that's just my only comment. But other than that, I really enjoyed this. Everyone's doing a great job. Good luck at 4 o'clock if you're also going at 4 o'clock.
Thank you so much.
Okay, I'll do mine. I thought everybody did a fantastic job. Prosecution's close. you said, we believe we did it. There's just something we wouldn't typically do. The defense, Taryn, you did a really beautiful job. Everybody did a great job. So but you started a few questions with "and" because you got into that flow, and it can drive people crazy to hear questions that do and. But really, everybody, great job.
Thank you.
I think I'm the only person that's left a comment. So I also want to congratulate everyone. I think everyone did a wonderful job. I was having trouble getting the side-by-side function, so I couldn't see the exhibits either. I had to toggle back and forth. So I'm not sure how relevant my comment is, but my comment does go to exhibits as well. I'm not sure if you used some of the exhibits, pictures of the car that looked completely disheveled and things of that nature. I would use my exhibits a little bit more, and I would display them as Juror Freeman suggested. I would display them more readily. But other than that, I think everything was wonderful. You were all very passionate advocates.
Thank you. Judges, thanks to all of you. We need you judges to judge these things, and you were all great at it. All right, thank you so much. It was a pleasure presiding over this round. I think both teams were incredibly well prepared and presented a very compelling.
Thank you for your judicial skills.
To the extent I have any, I appreciate the comment. Okay, so thank you again. Go get some rest and good luck in your next round.
Yes.
Good luck.